Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, Judge of your Webb County Court at Law 2. This is the Family Law Docket for Tuesday, February 10th, 2026. The time is now 2:18. Court is now in session. Assisting us today are Cecia Rodriguez, Court Administrator and Interpreter. Ms. Cynthia Flores is the Family Law Court Coordinator. Video conference co-hosts this afternoon include Ms. Rodriguez, Mr. Cordova, Ms. Ramos, Ms. Cuellar, Mr. Hernandez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Flores.
Yes, Judge. First counsel in person is Attorney Nelly Salazar, and for Ms. Attorney Eli Soto.
Page 1, Case 1, Adriana Ochoa versus Fernando Bouvier, cause number 2008 CVO 430C3. Good afternoon, Ms. Salazar. Court marks you present.
Inaudible.
Good afternoon, Your Honor. Can you guys hear me now?
We can hear you loud and clear now. Court marks you present in person. Speak into your device and tell the court, are you Fernando Bouvier?
Yes, sir. Good morning. Good evening. Sorry.
Good afternoon. Court martial present, participating by video conference. As you can see from your device, your lawyer is present in person. Adriana Ochoa, are you present? Court marks Ms. Ochoa not present in person, not present by video conference, and takes judicial notice that she was served with process October 18, 2025. Ms. Salazar.
Yes, Your Honor. So we're here today because we filed a motion to modify and clarify the parent-child relationship. The last time that we were before the court, I had asked if we could have more time to confer with the Attorney General's office to come to an agreement. And today we have reached an agreement. So I was hoping that we could put it on the record today.
Sure. Mr. Gonzalez, Raul Gonzalez Jr., are you making an appearance here on behalf of the Office of the Attorney General?
Yes, Your Honor, I am.
Welcome to court, Mr. Gonzalez Jr. The court marks you present and participating by video conference. Ms. Salazar, go ahead.
Yes, Your Honor. So as per the agreement reached with the Attorney General's office, on March 4th, 2010, this court ordered Mr. Bouvier to pay child support in the amount of $250 every month and medical support in the amount of $113 every month. As of today, it appears that Mr. Bouvier has child support arrears in the amount of $20,311.45. But since 2019 to the present, Mr. Bouvier has lived with, possessed, and supported the children on his own. As a result, the Attorney General's office has agreed to give Mr. Bouvier possession credit, relinquishing any further claim to the $20,311.45 of child support arrears. They have also agreed to relinquish any and all interests which may have occurred during that time. And as for the medical support, as of today, it appears that Mr. Bouvier has medical support arrears in the amount of $10,391.02. But since 2019, Mr. Bouvier has possessed the children and supported them by himself. So as a result, the Attorney General's office has agreed to give him possession credit and will relinquish any claim to $9,131.01 in medical support arrears. And this includes any interests which may have accumulated during that time. So Mr. Bouvier is only responsible for paying in medical support arrears $1,261.01 at a 6% interest per annum.
1,061
and 1 cent.
Oh. Any other?
It's $1,261.01.
Any other part of the agreement?
Yes, and it so Mr. Bouvier has been ordered to pay medical support judgment by paying $50 each month beginning March 1st of 2026 until the amount is paid in full.
Mr. Gonzalez?
That sounds right, Your Honor.
All right, Mr. Bouvier, you heard your lawyer tell the court what the agreement is in this case. Is that your agreement?
Yes, sir.
All right. One more question. Mr. Bouvier, raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
May I lower your hand. Is your true and correct name Fernando Bouvier?
Yes.
Mr. Bouvier, did you hear the agreement that was told to the court by your lawyer?
Yes.
Is it
I have knowledge of that.
Is that your agreement?
Yes, sir.
Do you believe that this agreement is in the best interest of your children?
Yes, it does.
Mr. Bouvier, in your case, cause number 2008 CVO 430C3, the court finds that it has exclusive and continuing jurisdiction over this matter. The court finds that you have an agreement. It's been stated on the record and confirmed. The court hereby adopts and approves the agreement and finds that it is in the best interest of your children. It is so ordered. These orders are due to the court honor before.
February the 23rd at noon by submission.
Anything else on this case, Ms. Salazar?
Your Honor, with regards to the motion to modify, I believe Mr. Bouvier was also looking. Well, I mean, his children are going to be aging out pretty soon. He has a 17-year-old son. I guess, is it okay if I can recall this matter, just to discuss with him whether or not he would like to move forward with becoming the sole managing conservator? I apologize. He wants to be a joint managing conservator, but he wants to have possession of the kids because currently his order doesn't state that.
Well, it sounds like the agreement here confirmed that the children live with him right now. So what happens in the real world should mirror the legal world should mirror what happens in the real world. So if you would like for me to place this case on recall, sure.
In this case, Your Honor, like I said, I think the children are aging out. If the order, I'm pretty sure the order meets his demand. Yeah, I guess if I can confer with him, and I apologize for that.
I'll call this case momentarily. Any other cases for Ms. Soto or Ms. Salazar?
Yes, Your Honor. That'll be page 3, number 7.
Michelle Yvette Gonzalez versus Jose R. Gonzalez, cause number 2021 FLA 2002 C3. Court marks Ms. Nelly Salazar present in person. Michelle Gonzalez, Jose Gonzalez, are you present? Court finds neither party is present in person or by video conference. Ms. Salazar?
Yes, Your Honor. So in this case, this was a divorce proceeding. We represent the petitioner, Michelle Gonzalez. They had gotten divorced and we were told to file a qualified domestic relations order so that she can get the retirement benefits that were ordered in the divorce decree. So we did submit one and it was signed by the court on June 9th. However, we did need to file an amended QDRO. So we are just asking the court if they could sign that amended order.
And the amended order both comports with the court's rendition and with the quadro requirements?
Yes, Your Honor. It was just a matter of using the wrong form. So the court actually did sign, we gave the court the wrong form. So we were just asking for the court to sign the correct one.
Based on your presentation to the court, well taken, so ordered. Now, do you have that proposed order already on file?
Yes, we do, Your Honor. And I did want to show it to the court because the court did sign one December 23rd. But it was kind of a mirror image of the first one that wasn't accepted. So the correct form, and if I could present it to, it should be on page 9 of that page. And I believe that is filed with the court.
The court has signed off on the retirement benefits court order and tending the original to the clerk's office. Should it be necessary to get it certified in any manner, just talk to the clerk's office.
Yes, thank you.
Any other cases for Ms. Soto or Ms. Salazar?
That is all, Your Honor.
All right.
Thank you, Your Honor.
Next case in person is Attorney Alonso Ramos. It's page 3, number 6.
Elsa Gomez versus Andres Jorge Gomez, cause number 2018 FLA 2421C3. Court marks Mr. Ramos present in person, Mr. Dancaus present in person. They're here on behalf of the petitioner, Ms. Claudia Garcia present in person on behalf of respondent. Good afternoon to all.
Good afternoon, Judge.
Speaking to the microphone and tell the court, are you Elsa Gomez?
Inaudible.
One more time, straight into the microphone, please.
Yes, I am.
Welcome to court. Ms. Gomez, court marks you present in person. The persons on your left and right are your lawyers. Speaking to the microphone, Mr. Gomez, and tell the court, are you Andres Jorge Gomez?
Yes, I am, sir.
Welcome to court, Mr. Gomez, court marks you present in person. The person to your right is your lawyer. Ms. Garcia, Mr. Dancaus, Mr. Ramos, what is the announcement?
Your Honor, I've been conferring with Mr. Ramos the past couple of weeks. And just for the court's information, I too filed a modification that is not set for today. And I just wanted to let the court know because that's part of what we've been trying to work out. What's present before the court is a motion for enforcement of spousal support. My client has good funds available in the amount of $10,000 to make a down payment to satisfy a portion of what's due and owing, Judge. Unfortunately, he had a personal check today, and Mr. Ramos, which I completely understand, prefers and requires a cashier's check. So my client is going to work on getting that by this afternoon and deliver it to Mr. Ramos either through my office this afternoon, no later than tomorrow. So that we can, and I believe the agreement was to make that payment. And we would get a setting at a later time to work with the Attorney General's office to confirm new amounts for arrearages, do the required releases for the spousal support, determine new child support, if at all, and get that cemented and entered into the court. And we would like, I know they would like a quicker hearing date, especially because we were hoping to turn in the money at the hearing today, Judge. And so I know that they want a quicker turnaround. Is that correct? And we would like to get that set along with the modification. We're working with the Attorney General's office to get those numbers and get new judgments entered and a new payment plan for my client, all the while my client is still making efforts to get more funds to pay down what is owed on all three of those items: child support, medical support, and spousal support.
Mr. Ramos, Mr. Dancaus, anything to add?
Everything there is correct, Judge. A quicker setting, if you could, Judge, just to verify that we do receive the monies. We were told the money were bigger today, but that's what we announced agreement.
It sounds like what you all need is two settings. You need a final pretrial hearing set within 2 to 3 weeks, and then a final hearing,
Sure.
because if I set it for status, nothing's going to happen.
Correct.
You
That's fine.
need to file something to give the court the authority to not do anything sua sponte.
Yes.
Ms. Flores, so give us two settings. Give us a final pretrial hearing, make that in less than 4 weeks, and then give us a final hearing after that. So 2 to 3 weeks on the final pretrial.
March 5th at 9 a.m.
All right.
Final hearing. April the 28th at 2 p.m.
Thoughts, comments, objections, or response, Ms. Garcia?
Your Honor, as soon as I get that cashier's check to Mr. Ramos, I will file an advisory with court just to complete the file.
Understood and well taken. Same questions, Mr. Ramos?
No, Judge, we have outside.
Court has heard no, sir. Mr. Dancaus? All right. Ms. Gomez, I've given your case 2 dates, March 5th and April 28th. Between now and then, keep in contact with your lawyers. They're going to continue advising you and preparing you for your court hearings. Do you have any questions for the court? Court has heard no. Thank you. Mr. Gomez, same questions. You're going to come back to court, so between now and then, keep in contact with your lawyer. Do you have any questions for the court?
No, I do not, sir.
Court has heard no. I wish you both very well. Have a good day.
Thank you, Judge. Can I be excused?
Yes, sir.
Thank you.
Yes, sir.
Other matters, but I'll wait my turn.
Oh,
Thanks.
next, is Attorney Andy Reyes, page 5, number 12.
Good afternoon, Judge.
Good afternoon. Rosalinda Vasquez Rodriguez versus Ovid Rodriguez III, cause number 2025 FLA 967C3. Court marks Mr. Reyes present in person, Mrs. Cotto present in person. They are the lawyers.
My client is present in the courtroom, Judge.
Judge in one of the rooms, if you can just have her call.
Or Sergeant at Arms will step outside. Are you Ovid Rodriguez III?
Yes, sir.
Welcome to court, Mr. Rodriguez. Court marks you present in person.
Thank you.
Judge, after a couple of rounds of mediation, we have a good news for the court.
Yes, that is correct, Judge. And Judge, this is Rosalinda Vasquez Rodriguez. She is the petitioner.
Step in front of the microphone, Ms. Rodriguez, and tell the court, are you Rosalinda Vasquez Rodriguez?
Yes, I am.
Welcome to court, Ms. Rodriguez. Court marks you present in person. Person to your left is your lawyer, Ms. Escoto. Mr. Reyes, go ahead.
Judge, we're pleased to announce, and I'm going to tender it to the court because signed it today, that in fact, informal settlement conferences do work after an unsuccessful mediation with Judge Hale and Mr. Lopez's work last week. We have signed off on a mediated settlement agreement that reflects the agreement of the parties as being in the best interest of their children, as being a just and right division of their estate. The parties are requesting that you pronounce and render their divorce today. We'll stipulate as to the jurisdictional requirements of the court. There is no expectation of reconciliation. So those are the wishes of the parties, Judge.
Sure. Mr. Reyes?
Judge, the old maxim of mediation, nobody walks away happy, but in this case, I think the 2 rounds of mediation that we did served to get us to the finish line. And so today, my client signed off on the mediated settlement agreement, Judge. I'd like to thank the court for giving us the time to really work on this, and it took quite some doing, but again, to the assistance of Mr. Lopez and Judge Hale, we managed to do it, Judge. And likewise, we're joining in with counsel, asking the court to pronounce and render the divorce. The specifics of the mediated settlement agreement will be incorporated to the final decree of divorce, Judge, and we'll sign off on it as soon as we get it from.
Judge, I'll prepare the decree and I'll attach that as an exhibit A. I just asked that Mr. Reyes prepare the deed.
The what?
The deed.
Not a problem. We'll
Question,
prepare the
Ms.
special warranty deed, Judge.
Mrs. Cotto, Mr. Reyes, 2 questions. I was handed the mediated settlement agreement, the final agreement. Is this for the court to enter into the court file, or has that been done already?
No, Judge, that we have not filed it. We tendered it to court today since Mr. Rodriguez signed it today. And so if the court wishes for me to take it back, I'll e-file it as soon as I get back, or if the court wishes to accept it now. And
I just wanted to know if I should hand it or if there's anything confidential that you wanted excluded out of
No,
public
Judge.
record. All right. So the court will receive and has reviewed the mediated settlement agreement, final agreement. The court hereby adopts and approves it. Let's just get some testimony on jurisdiction and reconciliation. Ms. Rodriguez, Mr. Rodriguez, would you both raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes, sir.
You may lower your hands. Petitioner may proceed.
Yes, if I can, Judge. Ms. Rodriguez, before filing the divorce, you had lived in Webb County for the last 90 days and in the state of Texas for the last 6 months, correct? Yes. And you were the one that filed for this divorce, correct? And you're asking that the court approve the mediated settlement agreement in its entirety today, correct? And there is no expectation of reconciliation with Mr. Rodriguez, correct? No. And with regards to all of the provisions having to deal with your children that are in that mediated settlement agreement, those are all in their best interest, correct? Yes. And with regards to the division of your assets with Mr. Rodriguez and debt, the mediated settlement agreement incorporates the agreement of the parties, and that is a just and right division of your estate. Is that correct? Okay. And you have not requested a name change, correct?
Which one? Kind of. Okay, okay. So we'll add, what would you like your name to be? My maiden name, Vasquez. Okay, so Rosalinda Vasquez. Yes, ma'am. We'll incorporate that into the, to decree judge, and I pass the witness.
Cross-examination, Mr. Rodriguez?
No questions of,
Any questions for your client?
yes, Mr. Rodriguez. Likewise, you, have lived here in Webb County for the past, 9, is that true?
Yes, sir.
And in the state of Texas, previous 6 months?
Yes, sir.
You had an opportunity to discuss with me the specifics of the agreement that we've signed off today.
Yes, sir.
And that incorporates not only child support, it incorporates visitation, it incorporates division of property. And by signing off on this document that we tendered to the court as the mediated settlement agreement, you're indicating to the court your agreement to all the specifics of that document. Is that true?
Yes, sir.
And likewise, you're asking the court to approve that agreement as tendered to the court. Yeah.
Yes, sir.
Now, before coming up here, you and I had an ample opportunity to discuss this document and the specifics of what's incorporated in the document. Yes.
Yes, sir.
And the work that I did for you, you are satisfied 100% with the work that I did for you?
Yes, sir.
I have no further questions.
Ms. Rodriguez and Mr. Rodriguez, in your case, cause number 2025 FLA 967C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider divorce. The court finds that you entered into marriage, but that marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were children born in the marriage, 2 children that were born in the marriage, no other children were born, adopted, or are expected. The court finds that you have an agreement regarding your children. The court hereby adopts and approves that agreement contained in your mediated settlement agreement, final agreement, and the court finds that that agreement is in fact in your children's best interest. Likewise, the court finds that you have an agreement regarding the division of your property, and that's contained in that same document. The court hereby adopts and approves your agreement and finds that it is a just and right division of your property. At this time, Ms. Rodriguez, the court changes your name to Rosalinda Vasquez. And at this time, Ms. Vasquez and Mr. Rodriguez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due to the court on or before
February the 23rd at noon by submission.
Will you do that?
just
You'll be back? Will you be back? February
Mm.
23rd.
I might not do that. Can we just submit? Did the court take by submission, Judge?
it's
Yes,
by
by
submission.
submission.
I'll sign.
You need more time.
No,
I'll have it ready, Judge.
I'll sign up, Judge.
All right. Ms. Vasquez, Mr. Rodriguez, just a notation that obviously life is hard and marriage and relationships are even harder, but this just shows that through good communication, through your lawyers, you can resolve a lot. So I commend you both for the work, the diligence that both you and your lawyers have put into this case, and a good resolution. I wish you both very well. More importantly, I wish your children all the best.
Thank you so much.
Thank you.
Ms. Vasquez, do you have any questions for the court?
No, sir.
Mr. Rodriguez,
No, sir.
good luck to both.
Judge, I have nothing further before the court might be excused.
Yes, sir. Good to see you. Tendering the original needed settlement agreement to the clerk.
Yes. Sir. Next case, page 3, number 8, Attorney Montemayor.
Yes, this is Ricardo Miguel Guerra Jr. versus Julie Renia Medina, cause number 2021 FLI 995C3. Court marks Mr. Montemayor present in person. Mr. Lozano also present in person. Good afternoon to both.
Good afternoon, Your Honor.
Good afternoon, Your Honor. We filed a Rule 11 this afternoon with both, I believe both are, it's unopposed, both our signatures should be on it. This case is it's an older case, Your Honor. There was a temporary order that the court had signed back on January 2024. And we are going to, we'd like the court to pass it. We're going to confer with the ad litem. The visitation schedule is in there, called for steps. It's a phase, you know,
Who is the ad litem?
Kiko Tamets.
Okay.
And so I talked to Mr. Lozano, advised him about the phase, the completion of the phase
Sure.
situation. So we're going to meet with the ad litem, and maybe we can come back in about 14 days to enter into a temporary order.
Understood. Mr. Lozano?
That's correct, Your Honor.
Well taken. And this is the first setting, so by policy, the court will take. And Ms. Flores, give us the next setting, please.
April 2nd at 9 a.m.
Thoughts, comments, questions, objections, Mr. Montemayor?
No, Your Honor, if we have an agreement, could we submit it by, or get the court order by
Absolutely.
submission?
Absolutely. You said at 9 a.m., did you not?
That is correct.
All right, April 2nd at 9. Same questions, Mr. Lozano?
Yes, Your Honor. We're gonna try to work something out, Judge.
Okay. I wish all persons well. Any other cases for Mr. Lozano or Mr. Montemayor?
That is all for both attorneys, Your Honor.
Good to see you both.
Thank
Have a
you,
great
Your
day.
Honor. Have a good day, Judge.
Next case is Attorney Claudia Lanessa Garcia, page 3, number 6.
That one has been called.
Next would be page 8, number 21.
Roberto Carlos Yuso versus Jocelyn Lopez, cause number 2025 FLK 943C3. Court marks Ms. Garcia, present in person, Mr. Del Barrio, present in person. Are you Roberto Carlos Yuso?
Yes, Your Honor.
Court marks you present in person.
My client is not present, Your Honor.
Person to your right is your lawyer. And court marks respondent Lopez not present. Ms. Garcia, Mr. Del Barrio.
Your Honor, we have an agreement. I received from Mr. Del Barrio around noontime, his client's signature to our proposed order in suit affecting parent-child relationship. I brought the order with me for my client to sign. I will go back to the office and have it scanned and e-filed with the court. But I would like to prove it up. I know that Ms. Lopez isn't here, but I will rely on Mr. Del Barrio's representation that she is in agreement with everything contained therein. And I will
Sure.
prove it up through my client.
Miss-
That is correct, Your Honor. Just for the record, I did provide her a copy of the proposed agreement. She did review. I did answer any questions that she may have had. And she did provide me with her signature and advised me that she would not be. So
Understood.
she is in.
Mr. Yuso, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand, Ms. Garcia.
Thank you. Mr. Yuso, you're the applicant in this case, correct?
Yes,
And you and Ms. Lopez have come to an agreement with regard to conservatorship, visitation, and child support regarding your daughter, Valentina Yuso, correct?
yes,
And you are a resident of Webb County, correct?
yes,
And you've lived here for at least 90 days, correct?
yes,
And your daughter is Valentina Yuso, date of birth December 1st, 2017.
yes,
And a couple of months ago, the judge did interview her in chambers on Ms. Lopez's request, correct?
yes,
Now, you all have agreed that both you and Ms. Lopez would be joint managing conservators of Valentina, correct?
yes,
And you would be the parent who has the exclusive right to designate the child's primary residence without regard to geographic location, correct?
yes,
And the agreement you and Ms. Lopez have is that she will have standard possession of Valentina first, third, and fifth weekends during the regular school year, as well as not during the regular school year, beginning at 6 o'clock on Fridays and ending at 6 p.m. the corresponding Sunday, correct?
yes,
And on Thursdays, we're going to follow the court's order from temporary orders where she would have possession of Valentina on Thursdays during the school year, on second and fourth Thursdays only, from the time school lets out until 8 p.m., correct?
yes, correct,
And all drop-offs and pickups will be at your residence, correct?
correct,
There's also a morality clause that she has agreed to. Correct?
correct,
And you will be in charge of enrolling Valentina in all extracurricular activities, correct?
correct,
You will each have daily communication. The parent not in possession will have daily communication with Valentina for 15 minutes. No more than 15 minutes from 6 p.m. to 7 p.m., correct?
correct,
You and Ms. Lopez have agreed that you would communicate exclusively through the app close program, correct?
Correct.
And there is an agreement that should she not be able to be physically present with the child at any time after 10 p.m. on any given day, she's required to give you a right of first refusal to pick up the child so that you can take care of her, correct?
Correct.
And there is an agreement that should she be away from the child between the hours of 9 a.m. and 10 p.m. For more than an hour, then she is allowed to have only her father, the child's maternal grandfather, watch her. Is that correct?
Correct.
Now, with regard to child support, there is an agreement that she pay you child support in the amount of $444 per month, beginning March 1st, 2026, and being due and payable each month on the first month after that. Is that correct?
Correct.
And she is ordered to pay medical support. Well, let me clarify. The child is on Medicaid, correct?
Yes, correct.
And there's an order for her to pay $50 of medical support to the Attorney General's office to compensate for that. Is that correct?
Correct.
Now, she was ordered to make child support and medical support payments during the duration of this case in temporary orders. Is that correct?
Correct.
And she failed to make any payments whatsoever in the last 7 months, correct?
That is correct.
She was ordered to pay $231.97 to you beginning August 1st, 2025, correct?
Correct.
And interest on that is 97, for 7 months, it totals $1,623.79 with interest at $97 for a total due and owing to you for $1,720.79 of child support arrearages. Is that correct?
Correct.
And she has agreed to pay that and render that a judgment, correct? In your favor. And she has failed to pay the $50 of medical support from August 1st to February 2026 in the amount of $50 per month, correct?
Correct.
So the total due and owing to you, including interest, or not owing to you, but to the Attorney General, is $371 of medical support arrearages, correct?
Correct.
And both of you have agreed that there will be a judgment against her for that medical support arrearage, correct?
Correct.
And both of you have agreed to a mutual injunction where you're each prohibited from causing physical contact or bodily injury or threatening the other party with imminent bodily injury, correct?
Correct.
You're each prohibited by communicating in person, telephone, or in writing with the other person, except in a threatening manner, except for arranging and notifying about the child, correct?
Correct.
And you're each prohibited from interfering with the other party's periods of possession, correct?
Correct.
And you're both prohibited from making disparaging remarks about the other parent or the other parent's family in the presence of the child or in earshot of the child. Is that correct?
Correct.
And do you believe that these agreements are in the best interest of your daughter, Valentina Yuso?
Yes.
Are you asking the court to accept this agreement?
Yes.
And is this your, I'm handing you what is an order into affecting parent-child relationship. Is that your signature where it says Robert Yuso petitioner?
Yes.
And you'd ask the court to approve and sign this order once it is electronically filed with the court.
Correct.
I pass the witness, Judge.
Mr. Del Barrio.
No questions, Your Honor. Just as I mentioned before, my client, by providing me with a signature and the same document that Ms. Vanessa Garcia provided to me, she's approved the agreement and we went over it, so, and I as well signed.
Thank you, Mr. Del Barrio. Court finds Mr. Julio Garcia, appointed guardian ad litem, present in person. Anything to add, Mr. Garcia?
No, Your Honor, I had already spoken to the attorneys about this matter. They had advised me that after I spoke to Ms. Lanes's client, that they had reached an agreement. I never had the opportunity to speak to Mr. Del Barrio's client. However, pursuant to the parties' agreement, I believe that it's in the best interests of the children and request the court accept.
Well taken, Mr. Yuso. In this case, cause number 2025 FLK 943C3. The court finds that it has jurisdiction. The court finds that there is an agreement between you and Ms. Lopez. The court has heard it, both from your lawyer and has heard the guardian ad litem's thoughts on this agreement. The court hereby adopts and approves your agreement in full and finds that it is in the best interest of your daughter. These are the orders of the court, and the orders are due honor before.
February 23rd at noon by submission.
Anything else on this case, Ms. Garcia?
No, Your Honor, as soon as I get back, I will e-file it with the court.
Mr. Del Barrio?
No, Your Honor.
I wish both of your clients well. More importantly, I wish your daughter all the best.
Thank you.
Good luck.
Thank you, Your Honor.
Be back when I get called.
I believe that's all for me. Maybe excused.
Ms. Flores?
That is all for both attorneys, Your Honor.
Thank you.
Good to see you, Ms. Garcia. Mr. Del Barrio seems to think he has another one. Okay,
Down the line.
Yes.
thank you.
Attorney Madeline, Escoto Lopez, page 6, number 15.
Yikes. How far? Any objections? Hearing none, go ahead, Ms. Flores.
I understand she is on page 7, number 20.
Jose Leija, Claudia Isela Leija Rodriguez, cause number 2025 FLB 1604C3, court marks Ms. Anderson present in person. Jose Leija, Claudia Rodriguez, are you present? Court finds no parties present. Ms. Anderson, go ahead.
Your Honor, this is our first setting, and I have been advised by my client that the parties are attempting to reconcile. So if we could just, if the court could grant us a little bit of time to see if the parties end up wanting to go forward with the divorce or not, so we could have some 90 days, Judge, if that's possible.
Absolutely. And I just want the clerk to confirm, is there any service on this case?
I don't believe.
No, Your Honor.
So three good and valid reasons. This is the first setting. There is no service, possible reconciliation. We'll take it on, and for all those reasons, give us a setting in May, please.
That's wrong.
This is a trial on merits on,
That'll be May 19 at 2 p.m.
any other cases for Ms. Anderson?
That is all.
No, Your Honor.
All the best to you and your kids.
Thank you.
Have a great day.
This will be Attorney Escoto, page 6, number 15.
Did you say 15 or 16?
Page 6, number 15.
Got it. Jessica Cruz Salazar versus Aaron Salazar, cause number 2025 FLA 1430C3. Court marks Ms. Escoto present in person. Mr. Julio Garcia was present in person. Jessica Cruz Salazar, Aaron Salazar, any parties present? Was your client present?
No,
Ms.?
Judge, no, she's not. And Madeline Escoto for Jessica Salazar, Judge. I can pretty much announce to the court that we filed an agreed motion for continuance, Judge. On this particular case, we've exchanged settlement offers, but because the value of the house is in dispute, we signed off on a Rule 11 agreement, appointing Paul Porras as the certified real estate appraiser to appraise the home, and our request to the court, if we can come back in about 2 to 3 weeks, we should have the case concluded by then.
Mr. Garcia?
Yes, Your Honor. Madeline and I have been going back and forth regarding settlement offers. It seems like a majority of the items that were contested seems to be agreed upon, except for I guess one big ticket item and maybe a couple other little details. But she is correct in asking the court for a little bit of time so we can get this appraiser, and hopefully after that we'll be able to settle this without the necessity of a mediator. If for whatever reason it goes sideways, then we may ask the court for that, but we're hopeful that we can get it done ourselves. Seems like the parties are.
Well, it sounds like you might need two dates, and the reason I think that I haven't seen the name Paul Porras in a while, but I know that his background and his qualifications. Any idea how
that
long?
bad?
No, this is
Usually 10 days.
10 days is okay. Okay, good to know. Give us those 2 dates just in case, Ms. Flores. Give us a final pretrial hearing in less than 4 weeks, and then a final hearing after that.
Final pretrial, March 31st at 2 p.m.
March what?
31st at 2 p.m. And final hearing, April the 28th at 2 p.m.
Thoughts, comments, questions, objections, Mrs. Cotto?
I'm hopeful, Judge, we'll get it done before March 31st. And so maybe on that day, we'll have an agreement before the court. And if not, we can go to mediation, Judge, hopefully with Judge Hale, before that date.
Sounds fine with me.
Fantastic. All right, we'll take in, and I'll call this case on March 31st. Thank you both.
Thank you, Judge.
Thank you, Your Honor.
Next case of Mrs. Cotto, page 6, number 16.
Veronica Contreras, Benito Antonio Bonda, call number 2025 FLA 1450C3. Court marks Mrs. Cotto present in person. Speak into the microphone and tell the court, are you Benito Antonio Bondak?
Yes.
Welcome to court, Mr. Bondak. Court marks you present in person. The person to your left is your lawyer. Speak right into this microphone and tell the court, is your name Veronica Contreras?
Yes.
Welcome to court, Ms. Contreras. Court marks you present in person. Pretty sure I saw Mr. Arce. He is present. Court marks Mr. Arce present in person. Mrs. Cotto.
Judge, I'm pleased to announce that we had exchanged settlement offers, and today we have tendered to the court in court a Rule 11 agreement with all of the terms, including stipulation as to jurisdiction, that the divorce be granted on the grounds of insupportability with no expectation of reconciliation, that the court find that the provisions dealing with the minor child are in her best interest, as well as a just and right division of the assets and the debts incorporated into that agreement, Judge.
Mr. Arce.
That is correct, Judge. We've been working on this matter. Did I know that Mrs. Cortez sent me a settlement agreement? We've been fortunate enough to get it resolved, Judge, and we have an agreement today.
It's wonderful and fantastic. Ms. Contreras, Mr. Bondak, would you raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yeah.
Both have answered yes. You may lower your hand. Who would like to prove up jurisdiction?
I'll do it with Mr. Bondoc. Mr. Bondoc, can you please state your full name for the record?
Benito Antonio Bonda Jr.
And before you filed your counter petition for divorce, you had been living in the state of Texas for the last 6 months and in Webb County for the last 90 days,
Yes.
correct?
Yes.
And the agreement that we tendered into with the court, you're asking that the court approve it in its entirety, correct?
Yes.
All of the provisions with regards to Bryce are in her best interest,
Yes.
and all of the provisions with regards to your estate with Ms. Contreras is a just and right division.
Yes.
And there is no expectation of reconciliation with Ms. Contreras.
No.
And you want the court to finalize the divorce today.
Yes.
Nothing further.
Anything on cross, Mr. Arce?
Nothing on cross, Judge. If I could just inquire of my client the same, Judge.
Absolutely. Go ahead.
Ms. Cortez, you heard the testimony from your husband this afternoon. Are you also in agreement with what he had testified and adopt his testimony in that the agreement is in the best interest of the child?
Yes.
And also that the division of properties is a just and right division? And I've gone over the agreement with you today, is that correct?
Yes.
And that is your agreement?
Yes.
And you're asking this court to grant you a divorce this afternoon?
Yes.
Pass the witness, Your Honor.
Nothing further, Judge.
I see your name is Contreras, and I think I know the answer, but I can't presume, and I have to ask just in case. Are you asking for a name change? All right. Anything else from any person?
Nothing further, Judge.
Judge, she just asking that she remain Contreras, Judge, but it would be essentially a name change, Judge, but that's her maiden name. I believe she just goes by Contreras.
What is the name on your driver's license? Okay. Ms. Contreras, Mr. Bundock, in your case, cause number 2025 FLA 1450C3, at this time, the court finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider a divorce. The court finds that you entered into marriage, but that marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there was one child, a daughter, that was born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your daughter. The court hereby adopts and approves your agreement in full and finds that your agreement is, in fact, in her best interest. Likewise, the court finds that there is an agreement regarding the division of your property. The court hereby adopts and approves your agreement and finds that that is, in fact, a just and right division. At this time, Ms. Contreras and Mr. Bondoc, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. The court has signed off on your written settlement agreement. I am tendering the original signed copy to the clerk. This all will now get reduced into writing, though that final decree of divorce is due to the court on or before
February 23rd at noon by submission.
and that will conclude this case. Ms. Contreras, do you have any questions for the court?
No.
Mr. Bondoc, do you have any questions?
No, sir.
I wish you both very well. More importantly, I wish your daughter all the best. Have a great day.
Thank you, Judge.
That is all for Mrs. Cotto.
May I be excused,
Have a
Judge?
great day.
Thank you, Judge.
Next,
Your Honor, I have one more matter, Judge, with Mr.
yes, you're on
Garcia.
that same page 6, number 17.
Jessica Nicole Hernandez versus Jose Angel Rodriguez III, cause number 2025 FLA 1619C3. Court marks Mr. Arce present in person. Mr. Garcia, Juan Garcia, are you present?
I'm present, Your Honor.
Good afternoon.
Welcome to court, Mr. Garcia. Court marks you present. You're participating by video conference. Jessica Nicole Hernandez, Jose Angel Rodriguez. Any other persons present on this case?
Your Honor, I was gonna make an announcement, Judge. Myself and Mr. Garcia, we're still ironing things out. Judge, we're hoping to come to an agreement this afternoon, Judge, so we're still conferring, Judge.
That's correct, Your Honor. We're still conferring.
Are you asking for another setting or to place this case later on so that to give you time to confer today?
Judge, if we could give us some time to confer, Judge, unless Mr. Garcia has another announcement. But we're trying to hopefully work out temporaries today, Judge.
Okay.
Mr. Garcia had filed a motion for a mediation, Your Honor, on certain issue. But we are hoping at least for temporaries that we can come to resolution this afternoon.
Let me place this case on pause, and this will be the first contested matter if it comes to that momentarily.
Thank you, Judge.
Thank you, Your Honor.
Stand by.
Excuse me.
Yes, sir.
Okay. Page 4, number 9, Attorney Christina Alba.
Arturo Villanueva versus Mariana Reina, cause number 2022 FLC 1544C3. Good afternoon, Ms. Alba.
Good afternoon, Judge Villarreal. How are you?
Very good. Thank you. Court marks you present in person. Mr. Romero, are you present? Court, Mr. Romero, Eduardo Romero? Court finds Mr. Romero not present. Are you Arturo Villanueva?
Yes.
Welcome to court, Mr. Villanueva. Court marks you present in person. The person to your left is your lawyer. Mariana Reina, are you present? Court finds Ms. Reina not present. Ms. Alba.
Your Honor, we filed a motion non-protonc back in 2024. Your Honor pronounced and rendered a name change for the minor child. The final order, which was agreed to by the parties, Your Honor, and the order was signed back in 2024. The order, though, however, only had the initials of the child and not the full name of the child. And so based on that clerical error, we are requesting a judgment non-protonc so that Mr. Villanueva can take the rectified order to vital statistics and make sure that the child's name gets changed. Your Honor, we also did provide a proposed order. However, I'm not sure if Your Honor wants that proposed order where it does indicate the child's full name, or do you want a whole new order submitted of the final order? I would defer to the court.
I don't have a preference. It's really whatever vital statistics need. Let me sign the proposed order. If that is insufficient, just file. I'll give you an orders due date right now.
Yes,
So. The court has signed the order on the motion for judgment non-pro-tunc, having heard the good and valid basis and reason. It is well taken. I'm submitting the original signed order to the clerk. Should it be necessary, let me give you an orders due date for the full version.
February 23rd at noon by submission.
So just ask and inquire of vital statistics whether that is sufficient. If it isn't, then just file something before February 23rd.
Absolutely, Judge. I'll have my client take both the final order and this order, and hopefully that'll work.
All right. The court has granted your request. Mr. Villanueva, do you have any questions for the court?
No, Your Honor.
I wish you and your children all the best.
Thank you.
Have a great day.
That's all I have, Judge. May I be excused?
Yes, good to see you.
Page 7, number 19, with Attorney Memo del Barrio.
Valentin Palomares versus Sandra Leticia Palomares, cause number 2025 FLB 1582C3. Good afternoon once more, Mr. Del Barrio.
Good afternoon, Your Honor.
Court Martial President in person. Good afternoon, Ms. Garcia.
Good afternoon, Judge.
Court Martial present by video conference. Ms. Garcia, is this Sandra Palomares behind you?
Yes, Judge, it is.
Welcome to court, Ms. Palomares. Court Martial present by video conference from the office of your lawyer, Valentin Palomares. Are you present?
He should be online. No, my office was trying to help him log in earlier, so.
Court sees there's a device labeled or titled Valentin Palomares. Mr. Palomares, please unmute your device. Court is making that same request electronically now.
Hello.
Are you Valentin Palomares?
Yes, sir.
Welcome to court, Mr. Palomares. Court martial present by video conference. As you can see and hear from your device, your lawyer is present in person. Ms. Garcia, Mr. Del Barrio, go ahead.
Judge, we're here for temporary orders, and the parties have agreed that Ms. Palomares will have a temporary exclusive use and possession of the homestead located on Leon Avenue. She will also have primary custody of their son, who will soon be graduating this coming May. Child support will be calculated in accordance with the stub that Mr. Del Barrio has just provided to me, and we will begin that for the payments of on the 1st of February, and we'll continue thereafter on the same date of each month thereafter. With regards to the vehicles, Judge, my client will have exclusive use of possession of the Mercedes and the Chrysler that is being driven by their son. I will delineate whatever vehicle Mr. Palomares has in his possession as well. I know he is residing out of state right now, but the parties will agree to a temporary injunction for the pendency of the cause, and I think that's pretty much it. Mr. Del Barrio?
I believe that's correct, Your Honor. Of course, it's all temporary. We should be looking into, we should have an agreement, I believe, between the parties. And speaking with Ms. Garcia, I think the main issue is really going to be the residents, the main residents of the home, of the parties. And it's just going to be a matter of whether it will be put up for sale or one or the other party will be buying each other out.
Correct.
All right. Mr. Palomares, Mrs. Palomares, the court has heard the agreement told to the court by the lawyers. Do you agree with all of this, Ms. Palomares?
I do.
Do you agree with all of this, Mr. Palomares?
Yes.
The court hereby adopts and approves your agreement. These are just temporary orders. Between now and March the 31st, these temporary orders are due to the court honor before.
February 23rd at noon by submission.
So you work under those temporary orders, and then between now and March 31st, keep in contact with your lawyers. They're going to continue advising you of your rights, answering your questions, and preparing you for your final hearing on March 31st. Mr. Palomares, do you have any questions for the court?
No.
Mrs. Palomares, do you have any questions?
No, I don't.
All right. I wish you both very well. Have a good day.
Thank you.
For both
Thank you,
attorneys.
Judge.
Mr. Del Barrio, Ms. Garcia, always good to see you both.
Thank
Have a
you
great
very
day.
much.
Thank you, Judge.
You have a great day.
Thanks.
Thank you.
Next, Attorney Julio Garcia, page 2, number 5.
Diana Ernestina Winston versus Robert Dillard Winston, cause number 2018 FLA 2352C3. Is Mr. Garcia present? Mr. Garcia? Thank you. Sure. Court has heard Mr. Garcia ask for more time as he concludes or tries to finalize an agreement well taken, and I'll call this case momentarily.
Thank you, Judge.
Yes, sir.
Your Honor, if we may, recall page one, number one.
Adriana Ochoa versus Fernando Bouvier, cause number 2008 CVO 430C3. Court marks Ms. Salazar present in person. Adriana Ochoa is not present, and Mr. Fernando Bouvier was present by video conference. Mr. Bouvier, are you still present? Court finds he is no longer present. Ms. Salazar, go ahead.
Oh, I apologize. Would you like me to repeat that?
Yes, please.
I'm sorry. Yes, Your Honor, that was my mistake. The order that you were initially going to render is correct. And, as my client had said on the record, it is what he had agreed to and wanted. So yes.
All right, and cause number 2008 CVO 430C3, the court finds that there is an agreement regarding this modification. The court has heard it on the record. It's stated on the record. Court finds that Ms. Ochoa was served with process October 18, 2025. This agreement is between Mr. Bouvier, his lawyer, and the Attorney General's office. The court hereby adopts and approves the agreement in full, and the court even heard that it is in the best interest of this child. It is so of this children. The agreement is hereby adopted. These orders are due to the court honor before February 23rd at noon by submission.
Thank you so much, Your Honor. And again, I apologize for that, but my client did want me to express his gratitude for this court and for the OAG's office for working with them. So thank you.
I appreciate that. Thank you, Ms. Salazar. Any other cases for Ms. Soto or Ms. Salazar?
That is all.
It's good to see you, counsel. Have a great day.
That is all for the person virtual, Your Honor.
Yes, ma'am.
Page one, number two, with Attorney Marta Figueroa.
Daniel Garcia versus Ana Karen Manrique, cause number 2012 CVL 325C3. Good afternoon, Ms. Figueroa.
Good afternoon, Judge. Good to see you, sir.
Likewise, court-martial present participating by video conference. Ms. Leticia Garcia, are you still present?
I am, Your Honor.
Welcome to court once more. Court-martial present by video conference. Court marks Mr. Raul Gonzalez Jr. present by video conference. He's here on behalf of the Attorney General's office. Daniel Garcia, Ana Karen Manrique. Any parties present?
Yes, Your Honor.
Yes, Your Honor.
Are you Daniel Garcia?
Yes, Your Honor.
Court martial present by video conference. Are you Ana Karen Manrique?
Yes, I am, Your Honor.
Welcome to court. The court martial present by video conference. Ms. Figueroa?
Judge, I'm sorry for interrupting. Adriana Benavides Maddox, I'm present for Julia Rubio.
Welcome to court, Ms. Maddox. Court marks you present participating by video conference. I think I'll let you all speak, but I think we should have taken this one off the docket. I know that there's a vacation letter out, but Ms. Figueroa, Ms. Maddox, go ahead.
Yes, Your Honor. Thankfully, with the assistance of Ms. Leticia Garcia, the parties were able to reach an agreement with respect to temporary orders designed to see how this proposed possession schedule will work, even though we are here on a final pretrial conference. Ms. Garcia believes that it's in the best interest of the children to enter some temporary orders. And may I announce them, Your Honor?
Yes, please.
Yes, Your Honor. Both mom and dad will continue to be named the joint managing conservators of the children. Mom will continue to be named the primary possessor. Child support will stay unchanged. However, with respect to possession and access, temporarily mom and dad will possess the children in 1 week intervals from Sunday to Sunday at 6 p.m., beginning this Sunday, February 15th, starting with dad. And that is the sum total of the agreement of the parties, Your Honor.
Ms. Maddox?
I believe that is the correct agreement between the parties and as recommended and approved by Leticia Garcia, the guardian ad litem for the minors.
Ms. Garcia?
Your Honor, child support will remain the same for this period of time as is. Any and other orders will also remain the same. Also, there is a loving and caring order that I will include on the temporary orders that I will draft for filing and accepted and agreed to by all the parties and the attorneys, Judge. I will also be including a couple of extra guidelines that I would request that parents and step parents be following for the ease of the children. Parents will be responsible for their daily homework and any needs of the schools and their classrooms arising during their periods of possession. Health insurance will remain the same as is right now. And we will, I will be in touch with the children during this time, Judge, just to make sure that things are going fine. And if this trial period works, then we may be ready for we have a TOM date already, Judge. I'm not sure exactly when that is, but I know we do have one soon.
Understood and well taken. Mr. Gonzalez, anything to add or comment on?
No objections, Your Honor.
All right, Mr. Garcia, do you have any questions for the court?
No, Your Honor.
Ms. Manrique, do you have any questions?
Not at this time. Thank you.
Court has heard the agreement stated on the record. The court hereby adopts and approves that agreement. That agreement is due to the court in form on or before.
Your Honor, orders are due February 23rd. Final hearing is already set for February the 24th.
I wanted to ask you about that, and I guess I'll start with Ms. Maddox. I was looking at the court calendar, and it looks like the vacation letter submitted by Attorney Rubio, the final date on that letter is April the 16th. This final hearing is scheduled on February the 24th at 2. Your thoughts, comments, questions, concerns, objections?
Judge, I'm confident that the parties will be able to finalize this then, and I'm happy to stand in for Ms. Rubio and not delay the parties in resolving this matter to completion. However, if they do need more time, then we can move it. And I don't think we'll know that until we see how this new temporary order plays in effect.
And so for that reason, Your Honor,
Just to crystallize, so no request for additional time based on that letter, but rather should it become apparent to the parties and or the lawyers that additional time is necessary to work under the temporary orders, then that will be lodged at the next hearing.
Yes, Your Honor.
So,
Got
Your
it.
Honor, because the next hearing is in literally 2 weeks' time, I would like to verbalize now that I don't think that a 2-week temporary order period for this 1 week possession schedule is long enough. I think that a 6-week possession period will certainly give everybody, especially the ad litem, the clarity that she needs. I don't want to speak for her, but I don't think 2 weeks is enough time.
I have no objection. I have no objection to that, Judge, as long as the parties are okay with that, specifically Mr. Garcia.
Mr. Garcia, well, let me hear from you. So what's being said and discussed and told to the court is that, so under temporary orders, you have some time, all parties have some time to work through those orders to see what works and what doesn't. Anything that doesn't work, you tell your lawyers so they come back and make that argument to the court. And if necessary, I put you under oath so I can hear that by way of testimony. Anything that does work, you just leave it in, right? So what the lawyers are saying is you need some time to work through those temporary orders. Everybody seems to be in agreement with that, but I would like to give you an opportunity to respond. Any thoughts on a final hearing in or about 6 weeks, Mr. Garcia?
No, sounds great, Your Honor.
Same question to you, so I give you an equal opportunity, Ms. Manrique. Any thoughts or questions on that?
No, I'm in agreement.
All right, we'll take it on all fronts. We will take the setting on February the 24th off of the court's docket and add in or modify it to a final hearing in or about 6 weeks. Ms. Flores.
March 31st at 2 p.m.
Any objections to any of this by any person?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, Mr. Garcia, keep in contact with Ms. Maddox. Ms. Manrique, keep in contact with Ms. Cigarroa, and both of you keep in contact with Ms. Leticia Garcia. I wish all persons well. Have a great day.
I do have a housekeeping question. Does the court prefer that I file an agreed motion and order of continuance because of the trial setting on February 24th?
I've just now asked and ordered the coordinator to remove it from the court's docket.
Okay, I didn't hear that part. Okay,
So we'll
perfect.
come back
All
on
right,
March
Judge.
31st at 2. All right. I wish everyone well. Thank you all for working diligently on this case. Thank you.
Thank
Thank
you,
you.
Judge. May I be excused? I have no further matters.
Have a great day.
Likewise.
Thank you.
Judge.
The same request here, Your Honor.
Have a great day. Good to see everyone.
Good to see everybody too. Bye-bye.
Next case, page 4, number 10, Attorney Javier Guzman.
This is Jessica Gomez versus Eduardo Garza, cause number 2023 FLA 247C3. Court marks Mr.
Good afternoon, Your Honor. Daniela Martinez on behalf of Mr. Guzman.
Ms. Martinez, welcome to court. The court marks you present. You're participating by video conference. Mr. Santos, are you present?
I'm present, Your Honor. Good afternoon. Here
Welcome
on
to
behalf
court.
of Mr. Eduardo Garza.
Yes, sir. Welcome to court, Mr. Santos. Court marks you present by video conference. Speaking to the microphone and tell the court, are you Jessica Gomez? Turn on the microphone.
Yes, I am.
Welcome to court, Ms. Gomez. Court marks you present in person. As you can see and hear from your device, your lawyer, Ms. Martinez, is present by video conference. Are you Eduardo Garza?
Yes, Your Honor.
Welcome to court, Mr. Garza. The court marks you present in person. As you can see and hear from your device, as you can see and hear from that device, your lawyer is present by video conference, and court marks Mr. Raul Gonzalez present by video conference. On behalf of the Attorney General's office, we have an entry and a motion. Ms. Martinez, Mr. Santos.
Your
Yes,
Honor,
Your Honor.
this is a matter that we mediated twice. As the court will recall, this case has been on the court's docket for approximately 3 years. I think the 30-year anniversary is coming up maybe tomorrow. We recently, on our last trial, the merit setting, we went to mediation with Judge Hale. That was our second attempt to mediate the matter. It was the date of our trial on the merits. Luckily, after a 1:30 a.m. Mediation that occurred just days prior, unsuccessfully not reaching an agreement, we were able to reach an agreement at our prior trial on the merits on all matters. We've since submitted a final decree of divorce that reflects all those terms, and we're asking that the court go ahead and approve it, being that we do have a fully binding mediated settlement agreement, and that there is no good reason that it shouldn't be entered at this point.
Ms. Martinez.
Your Honor, we're also here on our motion to withdraw as counsel. So Mr. Santos is correct. We did mediate this case twice. At the last mediation on July 24th, 2025, the parties entered into a mediated settlement agreement, which was signed by all parties. After that mediated settlement agreement was signed, our client, Ms. Gomez, told us that she was no longer in agreement with the mediated settlement agreement. And so she did not agree with signing the final decree of divorce that was prepared by Mr. Santos's office. And because we're not seeing eye to eye on how to move forward with the case, we prepared and filed a motion to withdraw as counsel.
Just want to acknowledge, Ms. Gomez, that I have received, reviewed, and considered your letter to the court. Looks like was filed February the 4th. So there's two things before the court. Number one is the final decree of divorce.
Your Honor, and I don't mean to interrupt, but did you indicate that there was a February 4th filing?
Yes.
I'm not sure that we were copied on that. I have an August 18th filing.
Mm-hmm. All right. I have before me the mediated settlement agreement, the final agreement. It's signed by both petitioner, respondent, both spouses, both lawyers, and the mediator. I just need someone to confirm, is this filed of record with the court?
I believe it is, Your Honor.
All right.
Yes, sure. Was filed with the court.
All right. So then the next question that the court has is Mr. Santos has filed a proposed decree of divorce. Mr. Santos, does this final decree of divorce, does it contain all of the provisions in its entirety and exactly of the mediated settlement agreement?
It does, Your Honor.
Have any changes or modifications been made that deviate from what's in that agreement?
None.
Ms. Martinez, have you had an opportunity to review that final decree of divorce?
Yes, Your Honor, we did.
Is there anything in this final decree of divorce, this proposed final decree of divorce, that doesn't comport, conform, or is in alignment exactly with the mediated settlement agreement?
I don't believe so. I believe it followed the mediated settlement agreement.
Do you have any objection to any provision contained in that final decree of divorce?
Your Honor, as counsel still for Ms. Gomez, my only objection would be that Ms. Gomez does not agree to the final decree of divorce as written, but I can tell the court that it matches the mediated settlement agreement that was signed by all parties.
All right. All right, there being no objection, the court will adopt and approve the final settlement agreement, and the court will sign off on that proposed decree. I guess the only question the court has, Ms. Martinez or Mr. Santos, on I'll address you in a bit. You may put your hand down. For jurisdictional purposes, who would like to prove that up, or would you like the court to prove that up? Mr. Santos, Ms. Martinez.
Your Honor, if you could prove it up, and I guess my first question would be, so is the court wanting to enter the final decree as is prior to hearing our motion to withdraw as counsel?
I'm going to prove it, and then we'll move on to the second thing, which is the withdrawal. Right.
Okay.
Ms. Gomez, Mr. Garza, would you both raise your right hands? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
You may lower your hands. Ms. Gomez, let me start with you because you are the petitioner in this case. Ms. Gomez, you filed for this divorce on February 9th, 2023. On that date, on February 9th, 2023, had you lived in Texas for 6 months?
Yes, Your Honor.
Had you lived in Webb County for 90 days?
Yes.
Are you currently married?
Still to this day, yes.
Right. What is the name of your husband?
Eduardo Garza,
What was the date of your marriage?
September 2015. Not quite sure the exact date.
All right. Then when did you stop living together as husband and wife?
December 13th of 2022.
And has your marriage to Mr. Garza become insupportable?
Yes.
Is there any possibility that you get back together, that you reconcile? All right. Is your true and correct name Eduardo Garza?
Yes, Your Honor.
Did you disagree with anything that Ms. Gomez has already stated to the court?
I am.
All right. Ms. Gomez, Mr. Garza, in your case, cause number 2023 FLA 247C3, the court at this time finds that it has jurisdiction. You know what, before I pronounce and render, let me give you an opportunity to tell the court anything else that you want to say. Ms. Gomez.
Yes, Your Honor. The reason why I'm objecting to that settlement is because
Eduardo has not complied with it. He was supposed to give,
Well, he can't. How would he comply with something that isn't signed?
well,
It needs this court signature before compliance can be effectuated.
but if you look at the settlement, he was supposed to pay me a lump sum within 60 days of that signing.
It's not valid or enforceable until I sign it.
Okay.
He can, I mean, he should morally, ethically, legally, I guess, but it's not enforceable. Without my signature, there's nothing to enforce.
So I have one question.
ahead.
So then me having 6 months to refinance after that signing, to refinance my home and my vehicle, so it's not yet enforceable or in place. So I still have another 6 months to refinance my home. That's what worries me.
Who here, Ms. Martinez or Mr. Santos, has the answer to that question?
Your Honor, I believe that that would be a breach of contract in the event that either party wanted to claim that there was a breach of contract. They could file a separate suit, or they could have brought it here.
Well, I know the procedure, but she's not asking on procedure. Her question is, how much time would she have to refinance? And I believe the more crystal question is it 6 months from the date of the settlement or 6 months from the date of today?
Your Honor, I don't know off the top of my head. I'd have to review that decree and its various provisions, including the MSA.
I would second that, Your Honor. I can pull it up right now.
You're the drafter, Mr. Santos. What provision is the 6 month period, refinance period located?
I'll let you know right now, Judge, if you don't mind, if you'll just indulge me just a second.
Page 28, provision P1, respondent Eduardo Garza shall pay the mortgage insurance taxes owed, so on and so forth, until such time that petitioner Jessica Yvonne Gomez refinances the home, i.e. within 6 months of the final order. To answer your question, it's 6 months from today.
That's right.
That's correct, Your Honor.
I got this. Ms. Gomez, did you have any other questions?
I do want to do some modifications regarding child custody and visitation. So I'm asking if you would allow me a little more time to do that, because there's been substantial changes in my children's life. My son was medically diagnosed with a very serious health condition. And there's been a lot of things, my children have come back and said to me when they're visiting dad.
So here's the thing with all of this. I think that those things could be good, right? Just and could be maybe possibly in the best interest of your child or children. But here's the thing. I've done this with hundreds, maybe thousands of people, men, women, children, husbands, fathers, wives, mothers, grandparents. And here's the thing about families is that people individually are always changing, and together we're always changing also. The forms of our family, the people inside our lives, outside our lives that come into our lives. And individually, I think if what you're saying is true, then individually there's been a change in your child. So what needs to happen under the law is that when you enter into a contract or a final decree of divorce or a settlement, that's true and correct as of that date, knowing that tomorrow, next month, everything's going to change. Everything's going to change. They're going to have a birth date or a series of birth dates. They're going to have an injury or a series of injuries. There's so many diagnoses and all these other things. So all this to say, I'm going to finalize this divorce right now because I think that's been overdue for some time. And then in the future, you're always welcome to come back and say, all of that was good, right, and just. However, from the time that you signed it, the final decree of divorce, to the present, and you said it right now, there's been a substantial change. And now you need to go back. All of us need to go back and modify that. And you come back to court and you prove that what you're saying is true. So don't think of this document as being correct tomorrow. This document just reflects your family as it existed and as everybody existed on the date of your settlement, knowing that things are going to change. You're going to change. Your children are going to change. Your ex-husband's going to change. He's going to make more money, less money, have more visits, less visits. I don't know. But you're always welcome to come back and tell the court, here's how our lives have changed. And now, Judge, you need to modify these orders based on our changes. Yeah. Do you have any other questions?
No.
Mr. Gomez, do you have any questions?
That's
Excuse me. Mr. Garza, do you have any questions?
No, Your Honor.
None?
Well, just one, in regards to the payment that I have to, make out from here to 6 months. I know it's just a sum total amount, prescribing, describing the paper. Can I do it in installment payments?
You have 60 days from the signing, which is.
No,
60
I'm
days
asking
from-
about the payment. Will not change if I make it like in.
Mr. Garza, I think it's best that we discuss that after the hearing.
No problem.
I think that's a little different. That might be asking for a legal opinion. So I tell you what, let's say this. Ms. Gomez, Mr. Garza, in your case, cause number 2023 FLA 247C3, the court finds that it has jurisdiction of this matter, meaning this is the proper court form and venue to consider divorce. The court finds that you entered into marriage in 2015, but you stopped living together as husband and wife in 2022. The court finds that your marriage, unfortunately, has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were and are 2 children that were born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your children. The court hereby adopts and approves your agreement in full. That's part of your mediated settlement agreement, and the court finds that that is in their best interest. It is so ordered. The court also finds that you have an agreement regarding the division of your property contained in a mediated settlement agreement. The court hereby adopts and approves it and finds that that is, in fact, a just and right division. Ms. Gomez and Mr. Garza, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. The court has reviewed the final decree of divorce. I have signed it, and I am tendering the original to the clerk's office. Ms. Gomez, do you have any questions?
I do, just really quick, Your Honor. I have a question. Yes. My question is that temporary orders are in place until today because now we're signing the final decree.
I suggest that either you get a copy of the signed order from the clerk's office or from your lawyer and just follow that perfectly.
Okay,
Did that answer your question?
no,
What's
sorry.
your question?
My question is that we were under temporary orders until the signing of, I guess, today. So that settlement does not start until this date. So we were still under temporary orders since we first came to our first hearing, which was back in March of 23, I believe.
You're asking a question going backwards. I'm not,
Today, sorry.
you're asking a question going backwards regarding temporary orders. I'm not exactly sure what the question is, and I'm not sure how that's relevant. You need to be worried about what happens today going forward,
Okay.
but I don't understand what your question is. So as of yesterday, you're under temporary orders. What is the question and how is that relevant?
That, I mean, if we were under temporary orders until today, or yesterday until the signing of our divorce today,
Yes, but why are you asking?
because it has a lot to do with our settlement agreement.
Has nothing to do
Regarding-
anymore. So
regarding
your settlement
expense.
agreement, your temporary orders, they're gone, they're done.
It's just.
Which is why I'm saying, and I was very clear, make sure you get a copy of the final decree of divorce from either the clerk's office or your lawyer's office, because all of that stuff, it doesn't matter legally. It matters to us, obviously, as people, as persons, as parents, as former spouses. Very, very important. But legally, all of that stuff doesn't matter. It happens now. It matters now. What happened today? The signing of the decree. Get a copy and just follow it from this. Don't worry about the past. You need to really be concerned now about what happens after today.
I just want him to listen to that because he thought we were already going to, I mean, we have signed in mediation.
Who
So
cares what he
it
thinks?
just goes by.
We can only focus and change ourselves. What he thinks is relevant only for me. If you come back to court and say he got it wrong,
Mhm.
I picked up a copy of the final decree of divorce and he messed it up 1, 2, and 3, and this is what you need to do, judge, based on that. But let's worry about that if and when it becomes a reality.
Yeah.
Yes. Yes, yeah, absolutely. Any questions for you, Mr. Garza?
No, Your Honor.
Ms. Gomez, Mr. Garza, this process has been long and difficult, but I got you to the finish line. I certainly hope that you do well, individually and together with your children as a different family. And I certainly wish your two children all the best. Ms. Gomez, Mr. Garza, good luck to you.
Thank you.
Thank you, Your Honor. Maybe excuse me.
That leaves, not yet, that leaves Ms. Martinez's request. Ms. Martinez.
Yes, Your Honor. The only thing now pending before the court is our motion to withdraw as counsel.
Mr. Santos, any objection?
No objection, Your Honor.
Any objection, Ms. Gomez?
No.
Mr. Garza.
No, Your Honor.
The court has signed that order. It is well taken without objection. Ms. well, wait a minute. I'm signing the order, Ms. Martinez. Just FYI, the court's preference on the proposed orders are just much more specific. So in the order, what my preference is that it would say that the motion is granted and that Mr. Guzman, Ms. Martinez, Mr. Guzman's firm, and anyone thereby associated therewith is hereby withdrawn or excused. But
Yes.
I mean, so this document references the motion, but I mean, so I'm going to sign it. If you want to submit an amended one that's clear, you can do so on or before.
February 23rd at noon by submission.
All right. Any thoughts, comments, or questions on that, Ms. Martinez?
No, Your Honor.
All right. Thank you, Ms. Gomez and Mr. Garza. Good luck to all.
Thank you so much, Ms. Martinez.
Thank you. And Your Honor, that's all I have before the court. May I be excused?
Have a great day.
Thank you.
Likewise
Likewise.
as well, Your Honor.
Bye.
Have a great day.
God bless you all. Thank you.
Next case in person, Attorney Nathan Chu, page 8, number 22.
Itamari Lopez versus Nahum Lopez, call number 2026 FLA 68C3. Good afternoon, Mr. Chu.
Good afternoon, Judge. Nathan Chu present for Ms. Itamari Lopez.
Welcome to court. The court-martial present in person. Are you Itamari Lopez?
I am, Your Honor.
Welcome to court, Ms. Lopez. Court-martial present. You're participating by video conference. Speaking to the microphone and tell the court, are you Nahum Lopez?
Yes, I am, Your Honor.
Welcome to court, Mr. Lopez. Court-martial present in person. Mr. Lopez, do you have a lawyer?
No.
Are you going forward without a lawyer?
Yes, Your Honor.
Court marks you self-represented. Mr. Chu, what is the announcement?
Judge, I filed a motion for continuance because I've been in a jury trial on the 49th, Your Honor. So I just want to come to the court and urge that motion.
Mr. Lopez, do you have any objections to that request?
No, I don't.
Well taken. Is that jury trial over?
Yes, I just returned not guilty, Judge, but my mind is a little bit bent right now, so I can't.
I certainly understand that. I signed the order granting the request. It is not objected to. Give us another temporary orders setting, please.
February 24th at 2 p.m.
Any questions on this, Mr. Lopez?
No, Your Honor.
Any questions, Mrs. Lopez?
No, sir.
We'll see you here on February the 24th. I wish you both very well. Oh, Ms. Flores, does the court have Mr. Lopez's email address?
Yes, Your Honor.
All right. Have a great day, both of you.
Thank you.
Great to see you.
Next case online, Your Honor, Attorney Juan Jose Garcia, page 4, number 11.
Melissa Monette Cortez versus Brian Alexander Hale, cause number 2024 FLI 785C3. Good afternoon, Mr. Garcia.
Good afternoon, Your Honor.
Court-martial present by video conference. Are you Melissa Cortez?
Yes, Your Honor.
Court-martial present by video conference, as is your lawyer. Silverio Martinez, Brian Hale, are you present? Court marks respondent and respondent's counsel not present. Court marks Mr. Raul Gonzalez present by video conference. He's here on behalf of the AG's office. Mr. Garcia, what is the announcement?
In this case, Your Honor, I don't think we have anything to pre-try.
All right. Anything for the court to consider, Mr. Gonzalez?
Yes, Your Honor, I just wanted to mention that the OAG just objects to any termination. And I believe there hasn't been any, the burden of proof has not been met for Mr. Hale to give up the termination of rights of his children.
And I believe my client is also objecting, Your Honor.
And I did want to ask, Your Honor, is the court going to appoint an ad litem to this case so I can put it in my notes?
Well, I could and I would and I should. Is there a specific request?
No, I'm sorry, Your Honor, not on my end. I'm just asking if the court is going.
Mr. Garcia, are you making that request?
No, Your Honor.
I certainly want to do anything so spontaneous. Well, let me ask it this way, Mr. Gonzalez. If you're objecting to the termination, Mr. Garcia is objecting to the termination, Mr. Gonzalez, do you believe that it is a legal requirement that the court appoint an ad litem?
I would believe it would be helpful, Your Honor. I'm not
Say it again.
100% sure. I would believe it would be helpful, Your Honor. Yes.
But is there a specific, is it a shall or a may?
I apologize, Your Honor, but I'm not 100% sure.
Mr. Garcia?
I'm not sure either.
I find no fault from either because neither of you, although you're objecting, you're not making the request. But it would seem to me that if the termination is going to take place at the request of Mr. Martinez's client, then he should be the one making the request. So at the final hearing, if it is a requirement that on a request that hasn't been made, there's your objection. All right. So I'm going to leave this case on, and that person isn't even here. The movant, the petitioner, the person making the request isn't even here. So let me leave this case on for March 31st at 2 p.m. And at that point, just crystallize your research, see if it's a requirement or not, and you can crystallize your objections at the final hearing. All right. If there's nothing else for the court to consider, Ms. Cortez, I wish you and your children all the best.
Thank you, Your Honor.
Any other cases for Mr. Garcia or Mr. Gonzalez?
Yes, Your Honor, for Mr. Garcia, page 5, number 13.
Juan Isidoro Uvalle versus Maria del Rosario Herbert Ordaz, cause number 2025 FLA 1188C3. Court marks Mr. Garcia present by video conference. Speak into the microphone and tell the court, are you Maria del Rosario Herbert Ordaz?
Yeah.
Are you Juan Isidoro Ovalle?
Yes.
Mr. Ovalle, your lawyer is present by video conference. Mr. Garcia, what is the announcement?
This case, Your Honor, it's a divorce, and I think your Honor had met with the children in this case, and we just wanted to see what the court's decision was going to be, Your Honor.
Well, it depends. What I mean, I don't have a decision yet. I met with the children. Mr. Uvalle, Ms. Ordaz, your children are Dimas and Dominic?
Yeah.
Yeah. This is a divorce, Mr. Garcia?
Yes, Your Honor. Basically, they don't have other than personal effects in the vehicle, Your Honor. And I think each is keeping their own vehicle, each is keeping whatever personal effects, and each is keeping whatever debts are under their name. I think the only point of contention was the conservatorship, Your Honor. I think my client wanted to keep the older child with them, and I think the younger child was going to stay with the mom. That's what I think my client was requesting.
Well, so Mr. Uvalle, your request to the court is that you keep that you have primary possession of your older child and Miss Herbert have primary possession of the younger child?
Yeah.
I mean, so folks, I have to hear that and I'll consider it, but just remember that the standard is what's in the best interest of the child and children, and what you have to present, Mr. Uwaya, is some good basis or reason to separate these children. I mean, you're allowed to do so, and there may be, but I certainly didn't learn of any good reason in their interview. But you can try to prove your case.
The reason I'm doing this is because my son spoke to me. And he told me he wanted to stay with me. And that's why I'm doing it.
Is that Ms. Herbert? Don't speak to anyone. Answer only questions when you are, and speak only when you are asked to. Mr. Uwaya, the court heard that the only reason you were asking for that is because your oldest child asked you to do that, to make the request. Is that the only reason?
And since he's already 12, yeah. And I believe he can decide by himself.
None of those things. I mean, I'll let you testify, but neither one of those things is going to get you to the place that you want. A child can say, I want to live at one place, and that's not sufficient legally for the court to do that. And number two, children can say whatever they want. I can say, I want to go to school, or I don't want to go to school. I want to take my medicine, or I don't want to take my medicine. And we don't give them a choice sometimes, because we as adults have to decide what's in their best interest. Does all of this make sense?
Yeah.
Mr. Garcia, I mean, I have to hear it. If you want to put on evidence, I'd be happy to hear it. Let me ask you, Miss Herbert, you don't have a lawyer. Are you going forward without a lawyer?
I will hire an attorney.
Do you think you need an attorney?
No.
Well, I mean, so don't, I just want to put it on the record that you do or don't have a lawyer. Don't think that I am asking that you have one or you don't have one. I just want to know whatever the answer is so that I can put it in my notes. Today, do you have a lawyer?
No.
Are you going forward today without a lawyer?
Yes.
Court marks you self-represented. Mr. Garcia, are you ready to do this prove up?
Yes, Your Honor.
Mr. Uwaya, Ms. Ordaz, I'm going to ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes. Yes.
Both have answered yes. You may lower your hands. Mr. Garcia, go ahead.
Thank you, Your Honor. Is your name Juan Uvalle?
Yes.
And you are asking for a divorce from Maria del Rosario Herbert Ordaz?
Yes.
Okay, and you've been living in this state for the last 6 months and in this county for the last 90 days?
Yes.
Okay, and you are getting divorced based on the grounds of insupportability?
Yes.
And there's no expectation of reconciling with your wife?
No. No.
Okay, and of this marriage, you had 2 children with your wife, is that correct?
Yes.
Okay, and the oldest one is Dimas Uvalle Herbert?
Yes.
And the younger one is Dominic Uvalle Herbert?
Yes.
Okay, and the older one is about like 12 years old?
Yes.
And the younger one is 6 years old?
Yes.
Okay, and you are asking that both you and your soon-to-be ex-wife be appointed joint managing conservators of the children?
Excuse me?
You're asking that both you and your soon-to-be ex-wife be appointed joint manager conservators of the children?
Yes.
However, you would like to ask that you have the exclusive right to designate, and would you prefer the right to designate for just Dimas Uvalle or also for Dominic Uvalle Herbert?
I did not understand.
I mean, would you like to have the right to say where the children are going to live, specifically Dimas Uvalle and Dominic Uvalle, or do you just want to have one children with you, Dimas and Dominic live with your ex-wife?
Yes, just Dima.
Okay, and you wouldn't like to have Dominic Uvalle Herbert also living with you?
No, not right now.
Okay, and why do you believe that just having Dimas Uvalle Herbert live with you is in the best interest of both children?
But like he stated, he's a minor. And he should be with the mother.
Okay, but why do you, I mean, would you like to have both children living with you?
I would like to, but I don't think that would be possible.
Why do you believe that's not possible?
But I think what I understood from what you said was that the laws of the United States only allowed me to have the 12-year-old.
No. But Mr. Valle, what I'm asking is, would you like to have one or both children living with you?
I mean, if it could be both, that would be fine.
Okay, and why do you believe that that would be good for both children?
Because they're brothers and they have to be together.
Okay, and who is the one that takes them to school?
Right now,
Yes.
their mother.
Okay, and what activities do you participate with the children?
Right now, with none of them, I'm not allowed to.
Okay, and why is it that you're not allowed to?
She made a comment on Facebook that my life is in danger.
And can you tell the court, is there any truth to that or no?
No, it's all lies, but
And Mr. Valle, what work do you do?
I'm an account manager at a beer dealership.
Okay, and how long have you been working there?
14 years.
Okay, and have you ever been arrested?
No,
Okay, and how do you know how much do you have any, how much do they pay you there per year?
$50-52 more or less.
Okay, and if the court were to award you custody of both children, would you be able to take them to school and pick them up from school?
Yes,
Okay, and Mr. Valle, why do you think that it's better for the kids to stay with you than it is to stay with the mom?
I think that when she takes them across, they could be in danger.
And why do you believe that they would be in danger?
Because of all the lies they make to me.
What lies?
I have them here on Facebook.
But what are the lies that you believe put your children in danger?
There, they put for me that I was a wife beater and that I would not provide for my children. And I would not give them any money. And I would never support them.
But you do love your children, is that correct, Mr. Uvalle?
Yes,
And if if the court were to award you the right to designate the children, where they live, you would take care of them for their daily necessities, is that correct?
yes,
Okay, and also if the court were to grant you the right to designate, would you be requesting child support from Ms. Herbert or no?
no.
I I have no further questions, Your Honor.
Ms. Herbert, do you have any questions for Mr. Ubaye?
I think so.
You may ask questions.
What do you want the children? They're better with me. I want to spend more time with my children. They're also my children.
Next question.
I have never refused for him to see his children.
Any other questions for Mr. Ubaye?
No.
Mr. Garcia, any questions for Ms. Herbert?
Just a few, Your Honor.
Go ahead.
Thank you, Your Honor. Ms. Ordaz, do you believe that you don't think that since they're both boys, that it would be better if your husband were to have custody of them?
No.
Why do you believe that it's in the best interest that you have custody of those two children?
Because my work allows me to have them. Because I've always been with them. Because the father has been there, but very little. I believe that as them being with me, they could also be with their father.
So, and then here's the other question: Has the older child ever expressed Dimas Uvalle Herbert? Has he ever expressed wanting to stay with his father?
Yes, he did mention to me that he did want to be with his father. That was after he spent the week of Thanksgiving with him. He did make that comment, but he had always expressed that he wanted to be with me before that.
And so he did express it. Has your other child ever expressed wanting to be with his father?
No.
Okay, and have you prevented my client at any point from seeing his children?
Never.
Okay, he has your phone number and or he also has your email in case he needs to message you?
Exactly, and he also knows where I live.
Okay, and are you also living here in Webb County?
Yes.
And you're also asking that you get divorced based on the grounds of insupportability?
Yes.
And when it comes to the division of property, you're keeping whatever personal effects are in your possession, and Mr. Uvalle is keeping whatever personal effects are in his possession?
Yes, we don't have anything.
Okay, and then you're also you want to be awarded whatever debts are under your name, and then he's being awarded whatever debts are under his name?
Exactly.
I have no further questions, Your Honor.
Ms. Herbert, is there anything else that you would like to say?
No.
All right, anything else from any person? All right. Oh, one other question. I always have to ask, Ms. Herbert, are you asking for a name change?
No, I have my own name.
All right, Mr. Ubaye, Ms. Herbert, in your case, cause number 2025 FLA 1188C3. The court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage, but that marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 2 children, sons, that were born in the marriage. No other children were born, adopted, or expected. I had a chance to meet and talk to both of them. I know exactly who they are, what their likes are, where they go to school, what their favorite subjects are. And I think they're well developed boys. I mean, I think you all know what's I'll tell you what, the court hereby appoints both of you joint managing conservators over your sons, except that you, Ms. Herbert, will have the exclusive right to determine their residence. Visitation will be extended standard because that is what you are electing here, Mr. Ubaye, which is what the law allows, plus more time, because that's what you have. You told the court you want more time with your children, with your sons. It is well taken and so ordered. Visitations will be extended standard. And what all of this means is that both of you have the same rights, duties, responsibilities, and obligations over your children, except that you, Ms. Herbert, will have the exclusive right to determine their residence. You'll have possession and access to your children as the law allows, plus more time through extended standard visitation. Let me ask Mr. Raul Gonzalez from the Attorney General's office to see if you can help and assist the court with some calculations. The court heard Mr. Ubaye testify that he makes between, I think you said between $50,000 and $52,000 per year, Mr. Ubaye?
I think so. We just changed companies, so I'm making a very little bit less.
All right, so the court will take the median or the middle at 51,000. Mr. Gonzalez, 51,000. 51,000 gross for 2 children. You may lower your hands. Are you responsible for any other child support payments?
No.
Your Honor, if I may ask a couple of questions.
Sure.
Sir, Mr. Ubaye, are the children, do you carry medical support through the children? Does Miss Ever Ordaz carry medical support? Whether it be through an employer or private coverage?
They don't have medical insurance.
Okay. And it's for 2 children, is that correct?
Yes.
Perfect. And Mr. Ubaye, are you part of a union?
Yeah.
He is part of a union.
No, I'm not.
Does Mr. Ubaye have any other children outside of the children listed in this order?
No.
All right, Your Honor. So in total, the monthly gross income set at 51,000 per year. I'm getting the monthly gross income is 4,250. We would likely medical support, we would set it through the government program at $75. And the child support guideline percentage would be set at 25%. So the projected monthly child support obligation would be at $880.38. So around $880, Your Honor, assuming the medical support set at 75.
$880. All right. So based on your testimony, Mr. Herbert, you may lower your hands. Your child support is hereby set at $880 per month beginning March 1st, 2026, with a reimbursement to the state of $75 per month beginning on the same date. Reimbursement for health insurance. Ms. Ovalle, you're ordered to enroll your children in state-sponsored or state-provided health insurance. The court orders all of this and finds that doing so is in fact in your children's best interest. Regarding the division of property, all of the belongings in your possession are hereby awarded to you, Mr. Ovalle, and all the belongings in your possession are hereby awarded to you, Ms. Herbert. The court finds that this is a just and right division, and the court finds that all of the provisions regarding your children that the court has pronounced and rendered today is in fact in their best interest. Mr. Ovalle and Ms. Herbert, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due honor before.
February 23rd at noon by submission.
Does the court have Ms. Herbert's email address?
Yes, Your Honor.
All right. Do you have any questions on any of this, Mr. Ovalle?
For the child support? Can I check that later on?
If you want to review, you can do it. I just did it based on your testimony.
Okay.
If you have any other information in the future to provide to the court that you're making more or you're making less, I welcome a review, but the court just did it applying your testimony to what the law says you should provide.
Okay.
Do you have any questions for the court, Ms. Herbert?
He hasn't paid anything for the last 3 months, which is December, January, February. Is that gonna be paid or?
Ms. Herbert, are there temporary orders or any support obligation orders signed by a court?
No, we hadn't agreed to that.
So it's from this day forward.
Okay.
Anything else in this case, Mr. Garcia?
No, Your Honor.
Ms. Ovalle, just get the orders filed before February the 23rd, Mr. Garcia.
Oh, yeah.
Mr. Ovalle, Ms. Herbert. It was a real pleasure talking to your sons. I think your children are some of the one of the best conversations that I have had. And I'd say that with all honesty and sincerity. I think Dimas's level of communication and his ability to communicate puts him among the best communicators I have ever spoken to. And it was a pleasure to spend a few minutes with your sons. I wish you both all the best. I wish you well. More importantly, I wish your sons all the best. Good luck to all. Oh, one more thing. In the orders, Mr. Garcia, I find that it is necessary for the court to order an evaluation of services for the school district that the younger child, Dominic, is enrolled in. So if there are any other resources, programs, or tools that are available to him, I would like for the school district to explore whatever vocabulary expanding and building resources are available. So just put that in the order, and Ms. Herbert can take that to the school district to see if there are any other resources.
Oh, Your Honor.
All right.
It's already in the vocabulary.
Very good. All right. Good luck to all. Any other cases for Mr. Garcia?
Yes, Your Honor. Page 7, number 18.
Elizabeth Adriana Alos Fernandez versus Jose Antonio Fernandez Perez, cause number 2025 FLB 1530C3. Court marks Mr. Garcia present by video conference. Elizabeth Fernandez, Jose Fernandez, are you present? Speaking to the microphone and to the court, are you Elizabeth Adriana Alos Fernandez?
Yes.
Court marks you present in person. Your lawyer, as you can see from the screen, is present by video conference. Are you Jose Antonio Fernandez Perez?
Yes.
Welcome to court. Mr. Fernandez, do you have a lawyer?
No, sir.
Will you be going forward without a lawyer?
For now, yes.
All right, court marks you self-represented. Ms. Flores, does the court have Mr. Fernandez's email address?
Yes, Your Honor.
All right, Mr. Garcia, go ahead.
In this case, it's set for final pretrial, Your Honor. At this time, I don't have anything to pretrial, Your Honor.
Just to me, as the clerk's office, was anything filed between today and the last setting for the court's consideration?
No, Your Honor.
All right, Mr. and Mrs. Fernandez, there's nothing for the court to consider today. You go straight into your final hearing, which is a trial on the merits on March 31st at 2 p.m. You told the court that you don't have a lawyer today, Mr. Fernandez, but you could have a lawyer on March 31st. If you choose to hire a lawyer, I highly suggest that you look for one as soon as possible, because that person, in order to represent you best, will need the most time possible to talk to you, to advise you, and to prepare you for your final hearing. So don't wait until a week before, but start looking for a lawyer now, if that's what you choose to do. Do you have any questions, Mr. Fernandez?
Can I make some questions?
You may ask.
I gave my wife $670,000. I stayed with 570. The rent for May to October, I have not received any. When I started my house, I had money which I used to start my house. It was $50,000 that I had in 1992. I'd like to see if I could get that back. And I'm getting divorced because honestly, I'm afraid of her.
Well, it sounds like all of these things could be and will be relevant at the final hearing on March 31st. Just be prepared to explain all of that by testimony or with any documents that you want. If you have any documents that you would like the court to consider, just make sure you upload those to Case Center. You'll receive an email on that if you haven't already. And then talk to a lawyer if that's what you choose to do. And it sounds like your case may be a little bit more complex. If it is, talk to a lawyer. If you choose to represent yourself, you're certainly welcome to do that on March 31st, but at least you give yourself that option. Do you have any other questions, Mr. Fernandez?
No.
Do you have any questions for the court, Mrs. Fernandez?
Como aclaración, hace 7 años enfermo de trastorno bipolar. Usualmente no.
Just as a clarification, he was diagnosed by 4 to 7 years.
All right. All of these things the court will hear on March 31st. Mrs. Fernandez, Mr. Fernandez, I wish you both very well. Have a good day. Any other cases for Mr. Garcia?
Yes, Your Honor.
All right. We'll stand by for a few minutes. Hold on. We stand. Please be seated. Good afternoon. Court is back in session and we are on the record. This is the family law docket for February 10th, 2026. The time is now 4:41. Ms. Flores, what is the next case?
Page 6, number 17, with Attorney Juan Jose Garcia, and in person, Attorney Ruben Arce.
Jessica Nicole Hernandez versus Jose Angel Rodriguez III, cause number 2025 FLA 1619C3. Court marks Mr. Garcia, Attorney Juan Jose Garcia, present and participating by video conference. Mr. Ruben Arce, present in person. Counsel, what is the announcement?
On this one, Your Honor, we do have an agreement on certain issues, but there's some other issues we do not have an agreement.
Jessica Hernandez, Jose Rodriguez, are you present? Please step forward. Step in front of the microphone and tell the court, are you Jose Angel Rodriguez III?
Yes, I'm Jose Angel Rodriguez III.
Welcome to court, Mr. Rodriguez. Court martial present in person. The person to your left is your lawyer. Are you Jessica Nicole Hernandez?
Yes.
Welcome to court, Ms. Hernandez. Court martial present in person. As you can see and hear from this device, your lawyer is present and participating by video conference. Mr. Arce, Mr. Garcia, who would like to tell the court their agreement?
Your Honor, again, Judge, we had a partial agreement on this matter, Judge. I believe that what we agreed upon is mostly property, Judge. There was a house, it had been sold, that's been divided. My client's to keep the vehicle in his possession, and Mr. Garcia's clients to keep the vehicle in her possession. I had submitted to Mr. Garcia a pay stubs, Judge, for child support. There's a one hiccup with that, Your Honor, is that my client had been previously ordered to pay child support, and that's being withheld already from his pay stub, Your Honor. So we're just gonna ask that that be amended. I'm not sure the Attorney General is still online, but there's already been withholding done, Your Honor, on prior occasion, but it's been, I guess, a couple of years back, Judge. So that needs to be modified as to the amount, Your Honor. In reference to the children, we did agree that both parents are to be appointed joint magic conservator of the children, Judge. Also, we did agree that Mr. Garcia's client is to be named the person to designate the primary residency of the children, and that's Ms. Jessica Nicole Hernandez, right? What we couldn't come to an agreement on, Judge, were certain things. One was a morality clause that we had requested, Judge, and also the visitation, Judge. That was the main issue and the main road bump that we have today, Judge. We did also agree, Your Honor, that the parent not in possession of the children shall have phone contact with the children from the hours between 8 and 9 for 30 minutes, Your Honor.
Anything else with regard to the agreement or the disagreement?
On our part, Your Honor,
Mr. Garcia has something else to add, Judge.
Mr. Garcia.
I think on our part, Your Honor, it's just she's also requesting to be able to enroll the kids in whatever school she wants to enroll them, Your Honor.
And we would just ask that they remain in their current school.
Mr. Rodriguez, Ms. Hernandez, raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? You may lower your hand. Let me start by asking you, Ms. Hernandez, because you are the petitioner, you're the person that brought this lawsuit. The court has heard from Mr. Arce, Mr. Rodriguez's lawyer, that you have at least 3 agreements with Mr. Rodriguez. The agreements are that both of you be appointed joint managing conservators. The second one is that you have the exclusive right to designate their residence. And 3, that the person not in possession of your children We'll have telephone communication between 8 and 9 for 30 minutes. Is that your agreement with Mr. Rodriguez?
Yeah.
Is that your full agreement? Was anything left out? Is there anything you want to change? Do you believe that this agreement is in the best interest of your children?
Correct.
Is your true and correct name Jose Angel Rodriguez III?
Yes, Your Honor.
Mr. Rodriguez, did you hear the agreement that was told to the court by the lawyers
Yes, sir.
regarding your children? And it's only temporary, but regarding your agreement, is this your agreement with Ms. Hernandez?
Yes, sir.
Is this your agreement regarding your children?
Yes, sir.
Was anything left out?
No.
Is there anything you want to change?
I wish I can change a lot, but no, but right now.
Oh, with regard to this agreement, and it's only
Yes,
temporary.
sir. It's only temporary, but yes.
Do you believe that this agreement is in the best interest of your children?
Yes.
All right, the court approves the agreement. Now you have three things that you don't agree on. So I guess let me ask you, Ms. Hernandez, because you're the person that brought this divorce or this divorce. I'm just gonna ask you some background questions and then I'll cede the floor to Mr. Garcia and Mr. Arce. Ms. Hernandez, how many children before the court? How many children do you have with Mr. Rodriguez?
3.
Their ages
2, 7, 13.
and their genders.
All female.
Who, Mr. Garcia, Mr. Arce, who's requesting these temporary orders? Who made the request?
I am, Your Honor.
All right, Mr. Garcia, go ahead. On
Thank
the
you, Your
clause of visitations and the school, go ahead.
Thank you, Your Honor. Could you state your name for the record, Ms. Hernandez?
Yes, Jessica Nicole Hernandez.
Okay, and when it comes to having the exclusive right to designate what schools or to enroll them in a certain school, why is it that you're requesting for you to have that right?
The reason I'm requesting is just that right now we recently sold our house, so right now I have to move in with my mom for the meantime. So where they were going to school, it was because we lived in that subdivision, right? So now that I live over here on the other side, I would still have to ask for permission to see if they're able to go to that school, not living in that area anymore now that we live in Mines Road. So Mines Road, it would be a whole other school that they would be needing to attend if they lived in that area, right? So I don't know in the moment. Right now, I live with my mom. Right now, they're still going to the same school that they're going. I'm gonna continue on having them finish the school year through there. It's just as far as next year, that's the arrangements I'm gonna have to make because on where I'm gonna be living at that time. I mean, I would, whether I would still live there with my mom, so they would go to the schools there in that area.
Understood. Mr. Garcia.
Your Honor, and as to the visitation schedule, you're requesting that it be standard visitation?
Correct.
Okay, and why is it that you're requesting that it be standard?
The reason I'm saying it's standard is that his schedule is very inconsistent. It does change occasionally. In the past 3 months, it's changed already like twice. So right now, what we have trying to, as co-parent, is that I work with him as far as on the weekends that he has off. We exchange the kids on his weekends that he has off, which is that it's gonna average anywhere between 1 weekend out of the month or 2 weekends out of the month, depending on his schedule. And as far as during the week, he's been getting the girls during the week on his Tuesdays and Wednesdays. He picks them up in the morning, takes them to school and drops them back off the end of the day on Tuesdays and Wednesdays that he has off. Now, that can also be inconsistent just because either they call him in because he has to do overtime or he has to go for whatever reason. One of his guys didn't go in, he has to go back to work. So it's very inconsistent, but I've been working with him. It's been occasion where, I'm sorry.
And as far as you know, he doesn't leave out of town to work, is that correct?
He goes to Ensenada to work.
But he comes back every day?
Correct.
Okay, and you are requesting that he have his visits, just a standard visitation, is that correct?
Correct. Like I
And
mentioned.
and you don't have a problem if he picks up the girls and brings them back during the certain days out of the week, or you
Yes,
do?
I'm okay with that as far as taking them to school and bringing them back after school when we already had agreed after practices because the girls also have practices. But I just wanted to be consistent. It's been a couple of times, once or twice, where he doesn't wake up and I have to call him to wake him up to come pick up the girls to take them to school.
Okay, and then when it comes to the morality clause, you're asking that there be no morality clause because What would be the reason?
The
Mr.
reason to it is that it's gonna be out in the open. I am pregnant. It's not his kid, so the other man is involved in this pregnancy. So that's the reason why I say not to put the morality clause for that reason
And when are you expecting the child to be born?
in June.
Okay, and when did your husband move out of the home, Mr. Rodriguez?
Last year, back in July, August. It was in
Okay.
between June, July, August. By August, he was done. He had left by August and he stopped paying the mortgage.
Okay, I have no further questions, Your Honor.
Cross-examination, Mr. Arce.
Yes, Your Honor. Ms. Hernandez, you had testified just a few seconds ago that you weren't planning on taking the children out of their current school. Is that right?
As of this moment, correct.
So,
Finish the school year, yes.
okay, so you're asking that, I mean, your plan is that the children remain in the same school until the end of this year, is that right?
Correct, yes,
So that would be probably through the end of May, is that right?
yes.
Okay, so you wouldn't have an issue if the court had ordered that the children remain in school at least until May, and then, because this is temporary orders, that temporarily they would remain in the same school, not to disrupt their daily activities and their schooling, is that right?
Correct,
So you are in agreement with that?
yes.
And it's only in the future, you're saying that possibly if you move, that's when you'd be looking at ultimately maybe moving the children somewhere that they're either closer to where you reside or where you're going to be residing, is that right?
Correct,
That for now, your plan is that they stay put.
correct.
As far as Mr. Rodriguez picking up and dropping off the children, would you agree with me, and is it a fair statement, Ms. Hernandez, that Mr. Rodriguez is active in the girls' lives?
Active as far as when he picks them up.
Well,
and-
that he's an involved father.
Correct.
Okay, so he does help you as far as picking up the children or the older girls and taking them to practice, is that right?
When he has time and he's not working, yes.
And how long has Mr. Rodriguez had this schedule where he either has his days off during the week and not on weekends?
How long, I mean, he's been working at this position for quite some time, so it's always been rotating. But he has weeks, so that's where it makes it complicated, because he works 8 days, he's off 4 days, works 7 days, off 2 days. So that's always been in that rotation.
Okay, so you are aware that if standard visitation, and I'm not sure if it's been explained to you, but if it is first, third, and fifth weekends, that he's not always going to be able to spend time with his girls because of the fact that he's not going to have those days off during that time, is that right?
Correct, that's why I've been working with him on his days off, I've been giving him the girls.
So you have been working with him prior, but now you're saying that basically you don't want to work with him anymore because you want it to be the standard visitation, which is first, third, and fifth weekend.
So what I'm trying to do is just trying to get stability for my kids. So he's been talking about getting another job. He's been talking about his schedule's gonna be changing again, about he's gonna go on for 7 days, off for 7. I just want something in paper as far as first, third, and fifth, so that if his schedule just change, if it does change, we don't have to come back again and be like, you know what, never mind, we're gonna change it again because his schedule changed again. So it's just something standard for now, but I'm willing to work with him.
So you had mentioned that you were willing to work with him. If he were to provide you a schedule, let's say a month in advance, where he already has the days set, not on the weekends, on the first, third, and fifth weekend, but on the first, third, and fifth week days, which would equal the same amount of time, 2 days during the first, third, and fifth week, would you be able to work with him if he gave you that set schedule and that's a schedule that he would need to follow?
So I guess my concern is that,
Yes or no?
okay, so I'm sorry, can you repeat the question? To switch the weekends over to during the week?
Right, if he provided you with enough time, let's say a month in advance of his monthly work schedule, and that coincided with the first, third, and fifth weeks of the month, would that give you enough time to then work your schedule around those days, if it's gonna amount to the same time.
No, because then I can never plan anything with my kids. I would have to be month-to-month base. That's inconsistent for them as well.
So you're saying to this court that you plan activities months in advance?
Yeah, my daughter's in a travel team, so yes.
So you did earlier state, Ms. Hernandez, that you've been working with him, or you're trying to work with him. But now you contradicting that by saying, you know what? If that's his schedule, that's his schedule, and if he's not able to visit with the children, that's just the way it is that right?
No. I'm wanting to put first, third, and fifth so we can have something in paper. If his schedule changes again, are we gonna have to come back again and be like, oh, we gotta get different days now?
But again, you understand that he's working for the first, third, and fifth weekends on the most part, is that right?
For the most part, no, because it depends on when the 8 days land. So he's gonna have off once a month or if not twice a month, the way his schedule works out. If you go and calculate it, it's he works 8 days off worse, he has a weekend off during the month.
So what you're testifying to now is that he's got a weekend off, but not 2 weekends off, not 3 weekends off. It most likely be only 1 weekend, is that right?
Between 1 and 2, the way his schedule is. He has, this month is 1, next month is 2, the following month is 1, the following month is 2.
And previously, Mr. Hernandez, he's been picking up and dropping up the girls to practice, is that right?
Lately, no. Because of his schedule, again, because he says he gets out late.
Okay, so when was the last time that he was able to pick up and drop up the children to practice?
We're talking about all of them, because he'll do one and not the other. I
Or
mean,
the two eldest?
the 2 eldest, okay, the last time maybe not this month, nor last month, I mean, I guess the month before that.
In reference to the morality clause, Mr. Hernandez, you had testified or explained to the court that you're pregnant, is that right?
Correct.
And you also had explained to the court that this is not Mr. Rodriguez's child, is that right?
Yes,
Although you're still married, how you're around, would it be safe to say you're 5 months pregnant at this point?
correct.
Okay, and the children prior to this relation or prior to you becoming pregnant, did they have any type of relationship with a person who you believe to be the father of the child?
A relationship, no.
Okay, so they didn't have any contact with this person prior to you having become pregnant, is that right?
Prior from pregnancy, no.
Okay, what about in the past 5 months? I mean, would it be safe to say that they had minimal contact with the alleged father of the child?
I wouldn't say, can you classify as far as what's minimum?
Well, you tell the court how much contact have your daughters had with this person?
It just depends, because I have visits, when I have the girls, I mean, I haven't really calculated as far as how much time he's had where we all been together. But I mean, I don't know, a handful of times a month, if that.
But clearly you're not married to this person because you're still married, is that right?
Correct.
And he's not, or let me ask you this, is he residing with you?
No,
And is that the plan, that during the pendency of this divorce that he reside with you?
is the plan to resign with me? Or is
No,
the
that my
plan,
question is during the pendency of this divorce, before this divorce is over, do you have plans to have him live with you?
correct, because I'm pregnant. And I'm
So
having his baby,
is
so
that-
it would make sense to live together, yeah.
No, my question is, it's just yes or no.
Yes,
Okay, so even though the children haven't had a lot of contact with him because these are not his children, then you're telling this court that it's okay in your eyes to have this person move in with you because you're having a new baby with him.
yes,
And you had mentioned that the children, and they're all girls, right?
yes,
You had mentioned that basically they're 13, 7, and 2, is that right?
Yes,
And you're telling this court today that you believe it's okay for you to move in a new man with a 2-year-old, a 7-year-old, and a 13-year-old, all girls.
I want to object, Your Honor, to asked and answered.
I think it's a different question. You can answer.
I'm sorry.
You can answer.
So can does it have to be yes or no question? Just because I
Yes, I've let it on go for so long now. Just answer the questions.
yes,
And do you believe that that's in the best interest of your 3 daughters, that you have this man around them?
yes.
Pass the witness, Your Honor.
Cross, Mr. Garcia.
I have no
Sorry, that
question,
would have
Your Honor.
been redirect. All right. Any other witnesses, Mr. Garcia?
No, Your Honor.
Mr. Garcia?
Your Honor, I'd like to call Mr. Rodriguez, Judge.
Yes, sir. Go ahead.
Please state your name for the record.
My name is Jose Angel Rodriguez III, sir.
And Mr. Rodriguez, you had heard the testimony of your wife, Ms. Hernandez, is that right?
Yes, sir.
And as far as you picking up and dropping off the children to practice, how active were you in doing that?
As I say, I'm pretty active. My daughter, Natalie, she has practice Mondays and Wednesdays. I do, and I have been the one taking her recently. I would say maybe like 80% of the time. When I do get out of work, I go straight. I would communicate with her mom that I'll be on my way to pick her up and take her to practice. I do pay for their sports that they're in, both my 2 children, our children, 13 and 7. And I do try my best to stay active as possible, whether I get out of work late or not.
Let me ask you this, and then just answer the
Yes.
question I'm asking
Yes,
you, Mr. Rodriguez.
Yes, sir.
You're employed, is that right?
Yes, sir.
And where are you employed?
I'm employed at Lewis Energy Group.
And is that employment here local?
It's an internet.
So you travel when you're employed?
Yes, sir.
Could you tell the court how a daily schedule for you would be?
My daily schedule will be, I'll wake up at 5:45, 5:50 in the morning, take off, and I'm usually there in Ensenada around 6:30, 6:45 in the morning. I go throughout my day, get the stuff I need, and I'm usually home every day. I would say around 5:30, 6 o'clock the latest.
Okay, so on the days that you're working, would it be practical for you to have your daughters, and are you going to be able to spend time with them during that time?
Oh, yes, sir. I can, if I'm home every day at 6, I can spend happily 2 hours, 2 hours and a half with them if I can. Yes.
Okay, but listen to what I'm asking you, Mr. Rodriguez. On the days that you're working, I mean, would it be better that you'd have a day off to see your daughters, or would it be better that you spend time with them when you're actually working?
Both.
Okay, and so let me ask you this way, how are you able to spend more time with your daughters if you're off or if
Oh,
you're
yes.
working?
If I'm off, I'll be able to, they'll be better when I'm off.
Okay, so are you off every weekend?
No,
Mr.
sir, I'm not.
Mr. Rodriguez? Okay.
No, sir.
So if the court were to grant first, third, and fifth weekends, which is standard visitation, would you be able to spend quality time with your girls if you only had them on those weekends?
No, sir.
And why is that?
Because depending the way my schedule is, the pattern, those weekends won't work for me to have them. I'll be at work.
So you'd be at work the bulk of the day?
Yes.
And as far as the days that you have off, you explained to the court that some of these days that you have off are during the week, is that right?
Yes, sir.
And when is that usually?
Usually during the week is Tuesdays and Wednesdays, Fridays and Mondays.
So let me ask you this, Mr. Rodriguez, are you able to get a work schedule in advance, and if so, how long?
Well, I can get it for the whole year. Where I do work, I can set it up for the whole year.
And are you able to then send a copy to Ms. Hernandez of your work schedule in order for you to get the 2 days every other week when you are on?
Yes, sir.
And would that enable you to spend more time with your daughters?
Yes, sir.
And do you believe that that's in the best interest for you to spend as much time with your daughters as possible?
Yes, sir. They do need their father, so yes, they do.
And would you consider yourself an active father in their lives, Mr. Rodriguez?
Yes, sir, I do. I've coached my oldest daughter and I continue to do the same with them. Coach them in their sports.
And what sports are they in?
My oldest is in basketball and volleyball. Our 7-year-old is Natalie, and she's right now in the basketball and wants to also attend volleyball.
And you had said that you actually pay for their extracurricular activities.
Yes, for both of them.
And when you had said that, or there was testimony by Ms. Hernandez that she had been working with you as far as the schedule. Is that what all you're asking from this court today, is that she continue to work with you and you be able to see the children on your days off?
Yes, I do.
As far as the children staying in the school that they're in, are you asking this court that they remain in that school because you believe it is in the best interest for them?
Yes, I do believe it's the best interest for them. That's where they, build their friends. They've been doing real good academically there and with their sports.
And how long have they been attending those schools?
Since we moved into our new home, which is, I would say now 5 years.
So for the past 5 years, they've had stability in those schools.
Yes, sir.
And all you're asking for is that they remain in those schools at least until the end of the year.
I would like for them, and if possible, stay there if they can, but yes.
And as far as the morality clause that we had spoken about and you were concerned about, Mr. Rodriguez, the fact remains that your daughters don't really have a relationship with the alleged father of this new child. Is that right?
Yeah, they don't.
And are you concerned, or is there concern because of their ages?
Yes, I do. I'm concerned not only for their ages, because they're also girls.
So your concern is that there's 3 females and they're gonna have contact with someone they've had limited contact with before.
Yes, sir.
And are you asking this court not to allow the father of the child to stay overnight? Is that right?
Yes, sir.
And not to have contact with the children at this time?
Yes.
Do you believe them having contact with the children would complicate issues even more?
Yeah, it'll complicate it, and I'm pretty sure put them in an awkward position for being 9 months in of this situation.
And in fact, you had voiced concerns about your oldest daughter already, is that right?
Yes, sir.
And what were those concerns?
The concerns of her not being allowed to talk to me for whatever certain reasons there is, which when it comes to her phone, she's crazy about her phone right now, and in order for her to be and have downtime on her phone, she has to listen. So if she doesn't listen, she gets downtime and she's not able to use the phone.
But in reference to this new relationship, Mr. Rodriguez, has it affected your oldest daughter?
I feel it has, and it's starting to. Yes.
I pass the witness, Your Honor.
Cross-examination, Mr. Garcia.
Thank you, Honor. Yeah, you're currently working for Lewis Energy?
Yes, sir.
And how long have you been working for Lewis Energy?
9 years, going on 10.
Okay. And last year you made approximately $103,000?
No.
How much
was
is
it again?
$103,000
Oh,
for the whole year?
Yes, this year has been the only, yes, this year.
Okay, so for 2025, you made $103,000.
Yes, sir.
Okay. And you don't have children with anyone else, is that correct?
Can you repeat that again?
Yes, you don't have children with from any other relationships, is that correct?
No, sir, just Ms. Hernandez.
Okay. And so what is how long you have to, or can you explain to us how many days out of the week you work for Lewis Energy?
The schedule is a little it's a little weird, but it's 7 days working, 2 days off, and then I go back for 8 days and I'm off 4 days off.
Okay, and how long does it take you to get from your home to Lewis Energy?
Like 25, 30 minutes.
Okay, and do you have to travel when you get to Lewis Energy? Where is it located?
It's located in Encinal, and my route is on 83. Highway 83.
Okay, and do you have to travel to other cities, or is it work around Encinar?
No, sir, it's just around Encinal, and like I said, I come home every day.
And what is your job title?
A lease operator.
Okay, and what is it that you do as a lease operator?
What I do is, I make sure that all, wells, because we do work with wells, make sure that everything is working properly from equipment, making sure our wells stay flowing. I also keep tabs on our, oil and, water tanks, make sure that all our, water and oil levels are low. I do also use, the phones, send emails, um, make reports, uh, submit work orders. So yeah, I do a little bit of a lot.
Okay. And so when it comes to the morality clause, your position is that the father of the baby should not be there at night. Is that correct?
Correct.
And why is it that you believe that he should not be there?
Because I don't know who he is, for one. Two, I don't think my daughters are ready for something like this to get pushed on them so quickly. So yeah.
Okay, do you have any evidence that that person is a danger to your daughters?
Mm,
Yes or no?
no.
Okay. And as far as you know, you don't know how many times your daughters have been present with the other father, is that correct?
From what I know is that I personally seen it myself when she was with them. As co-parents, how she said, we had spoke about it that he would never be present, and he was that day. And from my understanding, it's been more than 5 times that he has been around my girls.
But wouldn't that be normal if he's there to visit his daughter, his future, the baby?
I agree, he can, but my girls shouldn't be involved around that. There's you can set specific times, locations to meet up, and I can more gladly appreciate I can take care of our girls while she's taking care of her stuff on the side. So yeah.
But you wouldn't agree with me that there has to be, or there at some point, or very short, or at this time that it's happening, that the children, I mean your children, and I guess the new baby will have some type of relationship and with that man present?
Yeah, within time, yes. But like I said, it's right now I feel it's being rushed on my daughters at the moment.
Have your daughters have any problems with their grades at school lately?
Objection as to relevance, Judge.
Relevance, Mr. Garcia.
Well, it's because he's claiming that it's producing a problem for his daughter. So I just want to know if there's been any actual, because he just says it's a problem or it's not right, but he hasn't really like
Overruled.
specified
Can you repeat the question again?
yes, has the children, or has your daughter's grades in school been going down in the last 4 months?
From what I know, like I said, I try to communicate with
No, but yes or no, do you know if their grades have been going down or been changing?
not that I know of.
Okay, that was my question.
Okay.
Okay, and has there been any incidents of violence between this man and your daughters?
Not that I know of.
Okay, and when it comes to so your workday, how early would you have your schedule for the following month?
I have my schedule set right now
For what month?
for all the way to. I have it right now set all the way to April,
Okay,
and I can finish the schedule for the rest of the year since I'm off today and tomorrow, so I can have it ready for you guys tomorrow.
Okay, and so you're just requesting that you have every first, third, and fifth weeks of the month?
No, I would like to proceed how we've been doing it, communicating when I have my days off, and when the way I've been seeing them during the week when I take them to practice, and try to stay active as possible.
Okay, but that is not what you were requesting. You were requesting just to have the 2 days that you get on the first, third, and fifth weeks.
No. You asked it. What was the question again?
Well, yeah, your request is that instead of you getting, and just to clarify, instead of you getting the first, third, and fifth weekend out of the month, you're saying that you want the 2 days to instead be during the week. Is that correct?
Yes, me and her have been communicating with, yes.
Okay. But you, again, so you're not asking just for 2 days, you're asking for more days out of the week?
If possible, yes. If she allows me to, yes. Like I said, I try to stay as active as possible. Once I get out of work, I'm more glad to be with them for an hour, 2 hours more, if possible. Like I said, I'm an active father. I've always been there since day one. I've been coaching my daughters. I've been there, all my life. So I try to stay active with them as much as I can. And if she allows me to.
At this time, I don't have any questions, Your Honor.
Anything else, Mr. Arce?
No, Your Honor.
These are only temporary orders, but I guess the question I have, Mr. Arce, is so what specific dates and times is your client requesting?
Your Honor, basically, Judge, my client does have a schedule, a set schedule that he gets in advance, Judge.
Right.
So in lieu of the first, third, and fifth weekends, Judge, we're just asking first, third, and fifth, same weeks, but his work schedule allows on a Tuesday, Wednesday, then those were the days he'd be requesting. So same amount of time. Judge.
How in the world would you ever enforce that?
Well, Judge, it's for temporarily, Your Honor, he has a work schedule and he can provide that work schedule to the petitioner, Judge. So that's basically what it would be.
You should have done it in testimony and evidence, no?
Well, that's what we were asking for, Judge, is that
But he didn't.
I'm sorry, Judge?
He didn't. He sat here through half an hour of testimony. He never asked for specific dates and times, if in fact he has his schedule.
Well, what we were requesting from the court, Judge, is that he give her the schedule and he basically.
How would this court ever enforce an order that isn't specific as to dates and
Judge,
times?
we would provide specifically as far as the dates go, Judge, in the temporary orders, Your Honor. So
but it's not agreed to. So if it's not agreed to, you have to present it by way of evidence and testimony to the court.
Yes, Your Honor.
Right. So to the court's point is how could the court grant the request?
Well, then just we could be as specific to that, Your Honor, in reference to the dates, but it would be the same amount of time, Judge, as far as first, third, and fifth week, and it would be 2 days, Your Honor.
Court still doesn't have dates, and I think that's the point. I look, folks, Ms. Hernandez, Mr. Rodriguez, I think, look, I'm going to give you a decision just based on the facts as they exist in your lives and before the court right now, the evidence and testimony provided to the court. So first, your agreement is that you be named joint managing conservators. The court hereby adopts and approves that, which means that both of you have the same rights, duties, responsibilities, and obligations over your 3 daughters, except that the agreement number 2 is that it gives you, Ms. Hernandez, the exclusive right to determine their residence. The third agreement is that there be daily telephonic, and I'll make it video conference if you want, daily communication, telephone or video conference from 8 to 9 for at least, you said 30 minutes. That's fine. And there's three children. I think that's good amount of time. So as to your 3 disagreements, the morality clause, the visits, and the school, as to the morality clause, there just isn't sufficient information in the record to permit the court to grant that request, because normally in cases where the court grants morality clauses is because one side or the other is either introducing another new person into children's lives or a series of people, and that doesn't seem to fit into the facts in this case. In this case, it sounds like Ms. Hernandez now has and soon will have a long-term relationship with one person. And Mr. Rodriguez, there is nobody on the planet that can change that. This person, for better or for worse, it is what it is going to have some sort of relationship with your 3 daughters for the rest of their lives. You can't change this. This court can't change it. And quite frankly, Ms. Hernandez has made some decisions that now she can't change that. So it would be it's going to happen, I guess is what I'm trying to say. The introduction of this person into their lives is going to happen. Now, if there were different evidence to the court that she had a new person, something different, but based on those facts and circumstances, those are the facts that exist in your lives as a family. Number one. Number two, visitations. To the court's points, the court heard you testify that you could have your schedule laid out months in advance or even a year in advance. You said, the thing is, but we're here now. I need to make a decision today, because if Ms. Hernandez violates the order and says you cannot see your children on that first Friday at 5 p.m. or 3:59 or whatever it is that the court decides or you agree to, then you can come back and enforce it. What I can't enforce is some document that doesn't exist or is somewhere else or wasn't brought to court or wasn't testified to. I can't enforce that. Nobody can. So without knowing anything else, the court is going to apply a standard visitation per the Texas Family Code. What the court is going to want to hear between now and then is, what communication have each of you had? In other words, if you say that you're not available on the first weekend, but you are available on the second, I want to hear that you communicated that, and I want to hear what the response was, and I want to hear if there was a denial, what good reason, cause, or basis there was to not allow you that visit. In other words, you're going to get standard because there is no evidence to the contrary, but I want to hear whether you can work together or whether you can't work together, and I want to know, if you can't work together, who is disallowing visits, right? So standard visitation. As to the school, the court heard that the school, there's no plan to change the school between now and the end of the school year. That's probably a really good thing, because we're less than 3 months out, 3.5 months out for the end of the school. I find that they should remain in their same school, and that is in their best interest. No change in school. The court is not going to give any person the right to change the school. So they are to remain in the same school until further orders of the court. Interestingly, I know that you both know the facts in your life, and the facts are different from what exists in the law. The law says that there's going to be a presumption that this child that's born during this marriage is Mr. Rodriguez's. So for that reason, Ms. Flores, give us 2 dates. Give us a final pretrial hearing in May and give us a trial in the merits in June.
Final pretrial hearing, Your Honor, May 5th at 2 p.m.
All right.
And then you said in June? Or
Yes.
July.
In July, mid to late.
July 9th at 2 p.m.
All right. So what the court is doing here is, so use this time between now and the end of the school year, May 15th, to work on these temporary orders. By the way, these temporary orders, the court finds that they're in the best interest of your 3 daughters, and they're due to the court on or before.
February 23rd at noon by submission.
Work through those temporary orders. Sorry, did you all say that there was currently child support?
Your Honor,
There is child support.
there's an amount, Your Honor, but I believe it was.
Good. I don't need to hear anything else, because there is zero testimony as to any changes in that. So prepare yourselves for the final hearing.
Your Honor, I did ask him how much he was making. That he was making 103,000 a year.
Okay. And what should I do with that?
Would you like to ask if the child support can be set at that amount?
At what amount?
It would be for 3 children, $2,032, Your Honor.
And what amount is there right now?
From what I see on his paycheck stub, it just says $69.23 that they take out every, I think 2 weeks.
You want this court to go from $60 to $2,000 per month?
Yes, Your Honor.
Response.
And we would object, being that there's already a prior order in reference to that.
I'm gonna give you all the same ruling, folks. Look, if you can get your schedule far in advance, come to court without it, and you have access to pay stubs and all these things and come to court without it, you're gonna live with the same rulings over and over again. There's gonna be zero changes unless you actually prove your case through evidence and testimony on both sides. So I'm not saying one over the other. Final pretrial hearing, May 15th at 2 p.m. Trial on the merits, July 9th at 2 p.m. between now and then, I need you all to work your best with the situation. It's
Yes, sir.
I'm sorry, it's just that's not, it's a medical support, because I was getting Medicaid for my first child 12 years ago. That's the reason why it was on place, but it's not child support. He has the card, so it goes back to him.
Mr. Garcia, do you have Mr. Rodriguez's income tax and pay stubs?
I did have the paycheck stubs that Mr. Arce provided to me, Your Honor.
Do you have his income tax?
I don't have his income tax, Your Honor.
Mr. Arce, how much time would be reasonable and necessary to provide Mr. Garcia, Mr. Rodriguez's 2025 income tax?
Judge, if I could have 10 days, Your Honor.
What say you, Mr. Garcia, is 10 days reasonable?
That's fine, Your Honor.
I think it's very reasonable. Let's give Mr. Rodriguez till the end of February 27th, a Friday.
Thank you, sir.
And that way, and do at least I don't know that you have, but if you haven't, the last 3 months of pay stubs. So just exchange that information. That way you can come back to court with all of that information, with your schedule, talk to each other between now and then, work with each other. You're gonna have to do this. There's 16 years. And beyond that, people assume, people think and assume that your obligations with children and when they turn 18 or when they graduate from high school, that's not true. Your ethical and moral obligations will go on when they're 45, 65, 75. And when you die, your estate still has obligations, even in death. So just work with each other, please.
Yes, Your Honor.
These orders are due to the court February 23rd by submission. I look forward to hearing. So the purpose of our meeting on May the 5th is what changes, if any, should be made, having now known your schedule, and if the visits are flexible, and who hasn't been allowing those visits, if any person. What attempts have been made to change that? And then we'll come back on July the 9th, and what the court needs to hear, Mr. Garcia, is how the presumption that this child now born, ostensibly by July the 9th, is not Mr. Rodriguez's. And I think that's your burden to rebut. Any?
I'll talk to my client.
Say that again?
I'll talk to my client about that, Your Honor.
All right. Anything else on this case, Mr. Garcia?
No, Your Honor.
Mr. Arce? Do
No, Judge.
you have any questions for the court, Ms. Hernandez?
Did we settle the whole child support thing? Or I'm sorry, I didn't understand that part.
I said that there wasn't sufficient information in the record to do anything different. So whatever exists right now goes forward at least until May the 5th. Now, at that time, your lawyer should already have Mr. Rodriguez's income tax returns and for the last year and 3 months worth of pay stubs. That should be sufficient information to know whether a change should happen or maybe should not happen. I don't know.
There's nothing in place right now for child support, because that was for medical support for Medicaid.
But why don't you all say this when you're presenting evidence and testimony?
And Judge, I supplied counsel with the pay stub, and it does have a delineation for, it says child support, Judge, as far as the amount. But I'll talk to Mr. Garcia.
Well, I tell you what, if you know, Mr. Arce and Mr. Garcia, if you know that the court is going to make that decision, why don't you all make a calculation and put that number in by agreement?
I'll talk to counsel, Judge.
Mr.
Do that,
Garcia?
Your Honor.
All right, there it is. All right. Mr. Rodriguez, Ms. Hernandez, I wish you both well, but more importantly, I wish you 3 daughters all the best.
Thank you.
Thank you, sir.
Have a great day.
Likewise.
Thank you, Your Honor. Have a good afternoon.
Excuse.
Mr. Garcia, Mr. Arce, good to see you both. Have a great day.
Thank you, Judge.
Your Honor.
Next case, page 2, number 5, with Attorney Julio Garcia.
Diana Ernestina Winston versus Robert Dillard Winston, cause number 2018 FLA 2352C3. Court marks Mr. Garcia, present in person. Diana Winston, Robert Winston, if you're present, please step forward.
Good afternoon, Your Honor. Julio Garcia Jr. here representing
Good
Diana
afternoon.
Winston.
Court marks you present in person. Are you Robert Dillard Winston?
Yes, sir.
Welcome to court, Mr. Winston. Court marks you present in person. Diana Winston, are you present?
Yes, I'm present.
Welcome to court, Ms. Winston. The court marks you present, participating by video conference, as you can see and hear. From your device, your lawyer is also present. He's present in person. Mr. Garcia.
Your Honor, we're here for final final order, or at least the final hearing date. The parties have entered into an agreement, Your Honor, and I just wanted to have the opportunity to prove it up, make sure the parties are in agreement. Today, I have an agreement that is signed by Mr. Winston. I did have a signature page that have been sent to Cindy, I believe, through maybe her email. And if she has the ability to print it out, we'll have my client's signature as well. We sent it, I think my office sent it to like 4 or 5 different people, but I don't know if anybody's there anymore. But if she has the ability to check her email, I could get her signature on it as well.
Get your client's signature?
That's correct.
Oh, I see.
We did some minor corrections, which delayed the matter a little bit. But so Mr. Winston is here. I can prove it up. Her signature should be present. We just need to see if we can take it out.
Ms. Winston, Mr. Winston, would you both raise your right hands? Do each of you solemnly swear or affirm that the testimony you'll give in this cause will be the truth, so help you God?
Yes, sir.
Yes.
Both have answered yes. You may lower your hands. Mr. Garcia.
Yes, Your Honor. In order to speed things along, I'll just advise the court that Ms. Winston had filed a motion to modify an agreed final decree of divorce. We supported it with argument and authorities for Your Honor to consider. Due to the fact that the parties have been working very well with each other, we entered into temporary orders. So the final order is basically going to be transitioning the original modification request from the temporary orders onto the final orders. And I wanted to state for the record that the main changes for this particular final order that Mr. and Mrs. Winston have agreed to is basically the following. They have agreed through the final order that the parties would, Ms. Winston will be named the sole managing conservator with the right to designate where the child resides with no regard as to geographical restriction, which is what was originally pled to. In the final order, Judge, there is a specification as to everything from pickup and drop-offs to visitation for weekends, which is a standard possession agreement that Mr. Winston has agreed to. Specifically, he wanted to verify that the provision that we put in the final order specifies for any party that does not have possession of the child, they'll have the opportunity to speak to the child between 6:30 and 7 o'clock. Obviously, any of these provisions, including possession, times of communication, are subject to their own mutual agreement. This is basically the fallback position, and they understand that due to the fact that that if they can continue to co-parent and communicate, that if this is only subject as to if they cannot reach an agreement, this is what they would be following. Additionally, Judge, and that is just for a reasonable daily communication. My client has also requested that ever since the temporary orders, Mr. Winston has not had the necessity to pay child support. Ms. Winston has requested and Mr. Winston has agreed that there no longer shall be child support paid by Mr. Winston to Ms. Winston. He will still continue to be responsible for the health insurance. The parties will still remain responsible to pay 50-50 for anything that's uninsured. I believe that Mr. Winston has his health insurance through his employment. And my client does have the requisite information and card necessary for that as well. Let's see here. Ms. Winston will also continue to have possession of all the important documents, including passport. Mr. Winston has a right to possess these items. And after the conclusion, we'll give them back to Ms. Winston. Everything is detailed and provided in the final order. Let me make sure that I have this correct. And obviously, just as we would do in every final order, Judge, Mr. Winston, if God forbid anything should happen to him, his responsibilities would still remain if there are any provisions to his estate. But once again, I've advised both Mr. and Mrs. Winston that we would provide notification to the Attorney General's office that Mr. Winston's responsibility for child support shall cease as of today, but he has not been having to have the responsibility to pay that child support since temporary orders had started back in, I believe, December of this year, early December or even late November. So he's already provided them with notice, and we will provide all the requisite information as well as an affidavit to the Attorney General's office, making sure that child support is no longer a necessity for Mr. Winston to pay. Make sure I have this one. If I can, Your Honor. Ma'am, Ms. Winston, could you please state your name for the record?
My name's Diana Ernestina Winston.
Now, Ms. Winston, I've read basically just a summary of what it is that you and Mr. Winston have agreed to on this modification. Is that correct?
Yes.
Is there anything that I have not mentioned to the court that you believe that is important to mention as of today that is in the agreement that has not been stated on record?
No, you've mentioned everything and gone over it in totality.
Do you believe that this modification is in the best interest of your child?
Yes, I do believe it's in the best interest of my child.
Do you believe and do you want the court to accept the agreement as has been provided and signed by you?
Yes, I do hope the court will accept this agreement.
Now, because Mr. Winston represents himself pro se, Your Honor, I'll pass the witness to allow him the opportunity to ask Ms. Winston any questions.
Mr. Winston, do you have any questions for Mrs. Winston?
No, Your Honor, I don't.
Mr. Garcia?
If I may, Your Honor.
Go ahead.
Sir, is your name Robert Dillard Winston?
Yes.
Now, Mr. Winston, I provided you with the order for the final, for the motion to modify today. Is that correct?
Yes.
Did you have an opportunity to review it, sir?
Yes, sir.
Now, sir, you know that you had the ability and opportunity to hire counsel, but you have chosen to represent yourself in this matter. Is that correct?
Yes.
Now, you heard everything that I read into the record. Is that correct?
Yes.
Are you in agreement with what it is that I read into the record, sir?
Yes.
Do you believe that this would be in the best interest of your child to allow this final hearing to go forward, sir?
Yes, sir.
Are you asking that this court agree and accept the final order as I have specified on the record?
Yes, sir.
And do you believe, once again, that I guess to summarize, that this would obviously be best for not only your son, but also for you and your ex-spouse?
Yes, sir.
Your Honor, at this time, I have the order on the motion to modify in my hands. This is the original where Mr. Winston has signed. I've just been provided by your office staff, by Ms. Cindy, to that provides my client's signature, which was sent over here. I don't know if you want to have Mr. Winston sign that document as well, or just have two separate pages of documents, whatever the court deems.
Well, I don't know that he has sufficient time to review, so
Same thing, Judge. It's just a signature page.
Put them both into the order.
What I'll do, Your Honor, is I'll offer the final order to the court for your signature, which would be on the second to last page, and request that the court accept this final agreement between the parties as agreed to and as read into the record.
Mr. and Mrs. Winston, the court has received, reviewed, and considered that order on the motion to modify. I have written in the date. I have signed page 23. I have listed renumerated pages 24 to now be 24A and 24B. In your case, the court finds that it has exclusive continuing jurisdiction over this matter. The court finds that you have an agreement. The court has heard your agreement. The court finds that it is in the best interest of your child. The court hereby adopts and approves your agreement in full. I find that that agreement is contained in the order to modify. I have signed that order and tendering the original to the clerk's office.
Thank you, Your Honor.
Mr. Winston, do you have any questions for the court?
No, sir, Your Honor.
Mrs. Winston, do you have any questions?
No, I do not, Judge.
Anything else on this case?
Real quick, Judge, when would be a good time to pick up a certified copy to allow Mr. Winston to have it so we can procure it to the Attorney General's office?
You could pick one up tomorrow.
Okay.
All right,
Thank you very much.
Mr. Winston, Ms. Winston, I wish you both well. More importantly, I wish your child all the best. Any other cases for Mr. Garcia?
That is all.
It's always good to see you, counsel.
Thank you, Judge.
Have a great day.
Thank you, Your Honor.
Yes,
Will
sir.
you be excused, Your Honor?
Yes, sir.
Thank you, Judge.
That is all for the attorneys, Your Honor, but there is, Mr. Gabriel Steve Juarez on page 2, number 4. In the wall of the court.
Ruth Garcia, Gabriel Steve Juarez, cause number 2016 CVW 604C3. Steve Juarez, are you present?
Yes. Yeah, it's because I had logged in late. Start.
I understand that, but I need you to start your video.
Right. Okay. I believe already. Yeah.
Are you Gabriel Juarez?
Yes.
Court martial present, you're participating by video conference. This is cause number 2016 CVW 604C3. Litigant Ruth Garcia, attorney Russell Jordan or Mary Capello. Is any person present on this case?
Not present.
Finds no persons are present. Have you had an opportunity to talk to your lawyer, Mr. Jordan, or the guardian ad litem, Ms. Capello?
No, Your Honor. I actually wanted to bring up. I don't know if this would be the time, but since the last court date, I didn't speak to my attorney. I just found out. I just had in mind that today was the court date, the following court date. However, in regards to Ms. Capello, I had brought up to the legal assistant, or to my attorney, that the last time when I was initially fighting for primary custody, I had to end up paying 100% of the ad litem's fees because Ms. Garcia, the mother in this case, doesn't work, and I had voiced the same concerns to my attorney. So as far as like to the best of my knowledge, that's what this court was gonna be about. That he was gonna, I guess, I mean, he did had mentioned something, but where Ms. Garcia can't pay for her 50% of the ad litem fees.
Well, let me ask you this. You're set for a final, this is the second setting for a final hearing on a motion to modify. What do you think two questions. What do you think we're doing here today? And number two, what is your request?
Well, my request was like as far as like the outcome, what I want to happen is like stricter visitations where they're what do you call it, visited, like maybe like through like a safe haven kind of thing was the example I was given. It's because there was an issue where this past summer we were following the standard possession order, and I believe by July of the 31st, or the date that it gives you for my daughter to come back to me, the non-custodial parent, she kept our child beyond that date, and I would make police reports, and I would take the proper courses of action. And it turns out that she made I have the report through the CPS. She falsified a report that I was being sexually and physically abusive to my daughter, and
Well,
that's pretty much.
you told the court that you want stricter visits, so it sounds like you want to enforce what you already have, or you wanting to change what you have?
Yes, change what I have, because right now, as the court order is,
All right, so
he does have supervised.
you're asking the court to modify what you have. Are you asking to go forward with your lawyer? Or do you want to give you another date so that your lawyer is present?
Yeah, well, yeah, I would like that exactly. Yes, because I mean, I did hire him. He's I don't know if
Ms.
he even
Flores,
logged in there.
give us two dates. Give us the third final hearing setting, and then give us a dismissal date 2 to 4 weeks after that.
Yes, Your Honor. And how much time for the final hearing, Your Honor?
Give us 30 to 60 days.
Final hearing, April 28th at 2 p.m.
And dismissal after that.
Dismissal, May 19th at 2 p.m.
All right, so keep in contact with your lawyer so that you're ready to go forward on April the 28th at 2. Do you have any questions for the court, Mr. Juarez?
No, so just by 4/28 is April 28 is when it should be settled whatnot.
No, that's a day that you need to prove to the court through evidence and testimony your case. Yes, sir.
Okay, all right. However, I would go about that with my attorney, right? Because since I hired him and he has all the details on everything.
That's exactly right, sir.
All right, got it. Thank you.
Right. I wish you well, sir. Have a great day.
Likewise, bye.
Page 2, case 3, Jennifer Buenrostro versus Carlos Longoria, cause number 2013 CVW 1179C3. Attorneys Philip Del Rio, Melissa Saldana, parties Jennifer Buenrostro, Carlos Longoria. Any persons present?
No one present, Your Honor.
Fines.
Your
no
Honor,
persons
we are part of this case and also the previous case. Just making notes.
I appreciate that, Mr. Gonzalez, court martial present, participating by video conference. On behalf of the Attorney General's office, there's a Rule 11 agreement. I don't know why we set this for entry of judgment, just to pass it over and over again. Just give us an order's due date.
It's Your Honor, February the 23rd at noon by submission.
So ordered. Page 5, number 14, Ana Silva Santos Sotero versus Antonio Chevelo Santiago Cabrera, cause number 2025 FLA 1316C3. Counsel or attorneys Francisco Tamez, Russell Jordan, Joey Tellez, or parties Ana Sotero, Antonio Cabrera. Any persons present?
No one present, Your Honor.
Court finds no persons present.
Your Honor, I apologize, but may I be excused?
Thank you for your attendance, participation, and diligence, Mr. Gonzalez. Have a great day.
Thank you, Your Honor. You have a blessed afternoon.
Thank you. There is a request for continuance. It is well taken. Counsel is unable to be present for a prior setting in the Fourth Court of Appeals. Court finds counsel is unavailable. There is an unopposed motion for continuance. It is granted. Give us another setting on this final hearing, trial and merits for a petition to terminate.
April 2nd at 9 a.m.
So ordered. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference for Tuesday, February 10th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, like the clerk's office and the sheriff's office. The court appreciates you all. Have a great day.